No, please. Yes, sir.
Well, item 60, my lord, I'm paying adjourn for a week, my lord, because I am not prepared. I informed the other side, my lord, also. Item 60.
Mr. Chakravarti, ask your junior to remind us.
My lord.
My lord, this matter.
Wait, Mr. Chakravarti,
আপনাকে ডাক
ওই ফাইলটা তোমার কাছে আছে? না, ঠিক আছে, অলরাইট, লাগবে না। Ask your junior to
My
remind.
lord.
Yes,
My lord, in this matter, I am appearing for petitioner in one matter, respondent. My lord, a very unfortunate state of affairs. My lord, after 25 years of practicing before this court, my lord, I cannot say anything against my client. My lord, kindly see this letter, but it is better I may retire from this brief. Because, my lord, on that day, what fell from your lordship, that first I am the officer of your lordship's court, and my lord, I am not getting the instructions. At least 20 times I have phone call, my junior phone call. Thereafter, I send the letters to the authorities that please kindly come and assist me so that we may know whether that person is actually getting pension or not. Because it is a question of disputed facts, and your lordship has been pleased to direct us to, my lord, place the pay slips. Now I am handicapped, my lord.
My lord, our
So it is better, my lord, with my respectful submission would be, if your lordship kindly fix a date in the next week,
no, my lord.
I will be surrendering my brief so that somebody may appear in enlightenment.
My lord,
Embarrassing. Your lordship,
my lord, we
kindly,
have objections, please. Here.
kindly appreciate
one submission.
my position, my lord. Categorically, once your lordship kindly sees
What
the
did we ask you to find out?
my lord, first is that whether the petitioner is getting pension or not. The second point is that if you would have,
Sir, we throw that if no further instruction is coming, you argue on merits. We will dispose of the matter on the
my lord, yes, my lord, today your lordship, my lord, has been pleased to fix the matter for disposal, as I understand. But that instruction is necessary. দিলে না সবই আমি মনে করো তো Now another thing, my lord, a relevant point which fell from your lordship, if the petitioner, according to his case, is appointed, which fell from his pay structure, pension, other thing, that also I indicated in my letter to the authorities. They kindly enlighten me.
why they are not doing so?
I don't understand, my lord. He's not.
Your officer was in court.
Yes, he stated that that person, the petitioner, is getting pension. And petitioner also stated in front of your lordship that he is not getting pension. So
Yes.
this is the, and kindly, my lord, have my lord kindly see the language of my letter, then your lordship will.
No.
So it is better, my lord, your lordship kindly save me.
Yeah.
May I retire from the brief? Somebody else will appear and assist
No,
your lordship.
Don't retire. It will, whatever record is there, you go through, we will pass our order.
My lord,
Whatever we understand from their submission,
my lord.
and if your officer dares to do so, we will appropriately pass strictures against him in sorry.
My lord, only one then.
But the problem is your client will not understand what will be the consequence.
Yes.
So if he
That is the
he
reason
does
I have
not
also
cooperate-
sent the letter to Delhi also.
Very good. If he does not cooperate with us,
Yes. So your lordship kindly fix any date in the next week except Monday, my lord, under the,
tell us.
my lord,
You tell us when we will fix, we will dispose of.
my lord, Tuesday, my lord, 24th,
No, 24th, I am not here, my lord.
25th,
26th,
My
it
lord,
can be.
My lord,
26th,
most
very well,
humbly, my lord.
26th.
My lord, please bear with me, my lord. I thought that today is my last date in court, my lord, because I am not in a position to coming to court, my lord. I am continuing I am conducting the case from since 2005, my lord. 2005, my lord. No, please, my lord. I'm not wasting your time, my lord. But, my lord, what they are doing, how they harassing the person, my lord. They file their in spite of getting letter from defense that he is eligible, my lord, they did not provide him job, my lord. It was dismissed in CAT. The letter was in their hand, my lord. Thereafter, here they have, I filed the application in 2005, my lord. The honorable judges, my lord.
Madam, what can
My
we
lord,
do? We are hearing
One
your
minute, my
matter.
lord, only 1 minute, my lord, not more,
No,
my lord.
if you are so angry,
My lord,
then
in the meantime, they filed another, my lord, only two days, my lord.
we are keeping it on 3rd
My lord.
October at 2 p.m.
My lord,
3rd October at 2 p.m.
my lord,
You
deeply
complete
obliged.
your arguments.
My lord, I
don't
will
seek
complete my
any-
argument as far the records is concerned.
Up the person concerned and tell him
Yes,
that when we
Yes.
have asked him to produce the pension
Yes.
payment order, if he does not do so,
yes,
we will pass appropriate order against
my
him.
lord, grateful, grateful.
My lord, before
Grateful.
appointing
And
him,
you
my
can
lord,
send a reminder
they
letter.
have withdrawn the papers from Anil Gupta.
Yes,
No,
my
we'll
lord.
collect the circular. We called him. We'll collect the circular. No, we'll collect it, the circular in the minute. Yes, my lord.
You are also
They have taken the brief from Anil Gupta and he appointed
No, we have
him.
corrected his particular brief which he was saying we
He
took
has
it.
done that.
We have
Petitioner
done
said
that
he has
also.
done that.
no, my brother is telling about
Yes, that circular, that telephone number we have given to the junior, they'll collect it by the course.
collect it and give a copy to him also.
My lord.
And only one indulgence I am praying.
No further indulgence.
My lord, if my learned friend also can produce a letter before your lordship on that day, my lord, because I am also in dark.
No, he has not received pension.
Yes,
payment.
that whether he has, my lord,
If record is sufficient, if that will be at his
If,
risk and
my lord, I understand, I
at his
understand.
risk.
I'm obliged.
Then
my lord.
after getting pension, he says, I am not getting pension.
Yes,
It will be at his risk.
my
My lord, no pension, no retirement benefit, nothing.
that has to be.
3rd
That has.
October,
Nobody can stand in the way.
3rd
Grateful.
October 2 p.m.
Great.
Yes.
If possible, my lord, I shall be appeared, my lord.
No, you come. Come on 3rd.
That's your
I don't.
Start at 2 p.m.
2 p.m. Deeply obliged.
জানি
My lord, in item number 3, Miss Salma Sultan Shah is appearing, my lord, for the petitioner, my lord. My lord, I have instruction to pray for not today, my lord.
Why not today, madam? It was fixed. They have disposed
My
of
lord,
the
due to some personal difficulty, my lord, she couldn't be present today, my lord.
Mr. Dhar, that order you are giving.
No, your lordship directed us to disclose the fate of that missed case, my lord.
Disposed of.
No, it is not. It has not been disposed of.
ওই কেসটা না 1 of 2024 বলে দাও
Miss case number 19 of 2005 টা কি হলো?
ওটা পাওয়া যায়নি
হ্যাঁ।
1 of 2000
হ্যাঁ।
ও আচ্ছা
Not with instruction.
বলে দাও
ওটা কি হলো 19 of 2005?
এই 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 আগের দিন আমি বলেছিলাম তুমি ছিলে না এই রিট ওরা রিট কোর্টে এসেছিল রিট কোর্টে আরেকটা অর্ডার নিয়েছে শেয়ার বেসিসে ওইটাকে ধরে ওই মিস কেসটা হয়নি কিন্তু
কি করে dispose of?
We'll come back, my lord. Other side নেই, we'll come back next week. ছেড়ে দাও না।
My lord,
Sir, We'll
I
come
will-
Copy to.
my lord, I'm not in this briefed in this matter, my lord. I will
Madam,
only.
you can hand over the paper.
একটা কপি দিয়ে নাও না দিয়ে দাও।
My-
We'll come back on next.
Oh, when can you come back? Tell us.
The lordship may fix it.
এনি ডে
The lordship may fix it.
No, whichever date is convenient to you. They are
Next Friday, my lord, will come.
next Friday.
Next Friday.
It will be there on next Friday.
আমার কাছে কোনো কথা নেই ওর কাছে একটা কথা
You know.
দিয়ে দিও
ওনারই বলার আছে। আপনি চলে আসুন। স্টেটের বেশি বলার নেই। কি আসছে? স্যার, আমি তোমার সঙ্গে আছি।
This is for expeditious disposal of the tribunal application.
We are from the private response.
The 1st February. চলে এসছো তো?
The date of the petitioner is, my lord, if thrice he has come back and gone back. On technical ground, I own, or technical ground, petition dismissed, remanded back. Again come, again decided in my favor, come back, again remanded back. This is third round.
Mr. Siddiqui, you have used the opposition in the tribunal.
But I do not have any instructions with regard to that one.
Have they used Mr. Basu?
Probably not.
But I do not have an instruction.
If not, let them do it.
Opposition
within
দিয়েছে
the-
আপনার? Tribunal. Lord, we have been directed, my lord, to produce the LCR before the learned tribunal.
Same thing.
That LCR is to be produced.
তাড়াতাড়ি বুঝলি তো?
The present petition has been
To page number 90.
90?
90. 90. পারবি?
Yes. Yes, what is the problem?
Yes.
You are for the private respondent.
Private respondent.
You were the respondents in the OA also.
Yes. My lord,
What is your objection to this?
the LCR in connection, sir, my lord, bottom portion of page 90, order.
Hmm.
LCR in connection with the case be called for from the controller, Kolkata Ticket Agency, through the learned register of the tribunal.
No,
Learned
what
reg-
is your objection, sir? Please listen to us.
My lord,
We will ask them to produce the LCR on the returnable date. Affidavits they will complete in meantime. You will also be at liberty to file. Just listen to us.
My lord.
Just listen to us. You would also be at liberty to file the opposition. Within whichever time you want, you tell us.
Lord,
We will direct the tribunal to make an endeavor to dispose it on that date, or any subsequent date we will indicate within 6 weeks or 8 weeks. How will that prejudice you, sir?
my lord, one thing on submission. Hearing before, he preferred appeal, and Honorable Division Bench presided over by Honorable Topobrata Chakraborty.
I did not
Rejected.
preside over the appeal bench, Mr. I have never
Standard.
presided over a
Standard.
appeal bench, 7 except any matter assigned to me.
Appeal.
কি করেছে?
Let me have a
কি ভুল
comment.
করেছে?
And that application rejected. কি application? তারা কপি দেবেন?
কি করেছি?
হ্যাঁ
On donation.
দাঁড়া, দেখতে এক সেকেন্ড কি আছে?
আপনি একবার
This is the earlier round. There is a same order passed by mine.
Earlier round.
I say thrice we have come back, ping pong, coming and going back.
My lord, this order, my lord, 15th of October 2021.
Yes, yes.
This is earlier round.
2021 WP.
2021.
This is 2024.
So,
In order, my learned friend's client, hearing before, 10 to 12 writ petition paper, writ petition paper, Yes. and he has been defeated in all occasions. In all occasions, he has been defeated. And one thing, my lord, that now the condition of the tribunal is there is a four bench, and this bench is sitting half of the day. Half of the day. This is my last information.
benches. What order do we pass? You tell us. You tell us what order we can pass.
Rejected. Date fixed, normal
No,
date.
this is of a separate original application. This was an earlier round.
No, my lord, not separate.
Subject matter, maybe lands and everything are same.
This case is continuation of this case.
Right.
What happened to the original application? What happened to that original
My
application?
lord,
Earlier original application allowed remanded back. I said thrice we came back and gone.
Oh.
Now after the tribunal ticker controller passed an order, then we again approach. Now this order has been passed.
my lord, same party, same property.
Absolutely.
In suit.
But we are not passing any order against you. We are not passing any order against you.
Now
On the contrary, we are giving you liberty.
Now, my lord, kindly,
No, may I have-
I am
May I have
just
my left ID?
producing the plaint of the case. He stated in the application that no civil suit is pending before any court. So civil suit filed.
But
In
sir,
Alipur
we are not on merits. You may have a very good case on merit. We are not saying so. We are only asking the state to produce the LCR as directed. You file your opposition in the meantime, and they will make an endeavor. Ashok.
directive
I am appearing for the petition.
What have you challenged?
Hello?
What have you challenged before us?
I have challenged the non-payment withdrawal.
First of February.
They are not giving your salary.
No, they are destined to join. That has been established in the tribunal's order, and there was a transfer order. I have challenged.
No, they have allowed him to join into Katihar, in Katihar.
Yes, Katia.
Are they disbursing your salary?
Presently, we are paying the salary from October onwards.
So now dispute right getting payment of
Past. In that respect, Lordship, I was very humbly praying for your Lordship for a direction to file a short affidavit, Lordship, within a short period of time, so that the matters, our pleading can be placed before your Lordship as to what is our point.
What is your point?
My point is, so there are two periods. The first period is 28 to 2023 to 9/5/2023. For this period, the payment has been made.
First is which period?
28 to 2023.
28 to
2023 to 9/5/2023. Salary for this period has been paid. And subsequently for the other period, which is from 10/5/2023 to 11/10/2023, this is a period which has been treated as a leave without pay. Therefore, nothing was paid to him because they didn't join the service.
But there was a tribunal order to allow.
Also, kindly sees the final order passed by the Honorable Tribunal, wherein it has been very clearly held by the Honorable Tribunal that the period from 10/5/2023 to the date they joined duty at Katihar on court's order is to be treated as period of absence.
No. Period held that the 28th February to 9th is deemed to have been spent on duty by the applicant.
Yes, 28 to 23 to 9/5/2023.
From 10th May to the date they joined.
Yes.
Is to be treated as period of absence.
Period of absence. Therefore, that is the period for which nothing was paid because that was treated thereafter as leave without pay.
Page.
No, this, if you'll also kindly see my instructions.
No, it was communicated to them.
Yes, if they were told about it.
It was not
No,
communicated.
why leave without pay?
Because they didn't join.
No, there was no sufficient leave in their credit.
No.
Yeah.
Well, these are things.
When they have joined.
These are the further things, Lordship, which I need to file by way of an affidavit.
That can you direct that a period shall be treated as a leave without pay, without taking any action, without giving them any opportunity of hearing or anything like that.
Well,
they have sufficient leave in their credit. You could have adjusted the same with unleave and anything.
Well, the reason is because they failed to join.
There was an interim order passed by the tribunal.
But if your Lordship kindly sees the
file. The dispute was that before the order was passed, you said they have been released. However, in the month of October, they were brought back and allowed to join in the same post which they were there prior to their order of transfer. So, in fact, you have done away with the order of transfer. Now, when you have allowed them to join, this period, if you want to treat it as a leave without pay, for that you have to initiate a proceeding. How can you withhold just for the sake of it? You are a statutory authority.
Because if you'll also kindly sees the last line of the final order passed by the learned tribunal, the period from 10/5/2023, the paragraph 5.6, I'm on the third line. The period from 10/5/2023 to the date they joined duty at Katihar on court's order is to be treated as period of absence.
Then go on.
Respondents are accordingly directed to release the admissible salary to the applicants and regularize the period of absence as per law in the light of the decisions above within a period of 90 days from the date of this order.
So you show us, following which law you have declared this period as leave without pay.
For this, Lordship kindly gives me some time. I shall come back with a short affidavit and I shall explain to your Lordship.
Also,
It's a matter they are
filing affidavit.
How can you improve your case, Mr. Dev? You are not in a position to tribunal said that you regularize and release the salary. Directed to release the admissible salary and regularize the period of as per law. You show us that how you have treated that to be leave without.
On what basis?
Because you have not challenged the tribunal's order. It is they who have come.
Very well, Lordship grants me some time. I shall try to satisfy your Lordship.
How long we will grant, Mr. Dev?
All the petitioners have.
Was any notice sent to you for
No,
pertaining to that period?
We have not been allowed to join, my lord. Even the departure they have given was not even given to join in a previous posting.
Now you are joined. Now you
We
are
have-
enjoying salary.
Yes, we do. 4.5 months, my salary is.
And now
We are
they are
not
drawing
having
salary.
more than 30 years.
Order. Was there any interim order? during the-
Yes, there is interim order. $110 million.
110.
Now, where is that order, Mr. Dev, that you have regularized by granting leave without pay? Where is that order?
It is 111 months. Another order will page 48. Transfer order has been stayed. Page 48.
This is, Mr. Dev, this is contrary to tribunals. For the period from 10th May to 11th October, you have regularized that as leave without pay in compliance of the order of the tribunal. Tribunal did not say grant him leave without pay.
So tribunal say that period is to be treated as a period of absence.
Yes, which has to be regularized by grant of leave. Now, if they have leave to their credit,
But that was not specifically directed by the learned tribunal.
that is for you to understand. Regularization by granting leave without pay, that is not the intent of the tribunal.
Kept in abeyance pay. Which was aberration in the event. The living order has been passed on that date. The transfer order petition will be kept in abeyance.
তার আগেই pass করা
Already passed on.
আসুক।
So we are calling for affidavit.
Our
See,
salary can be given. In
Huh?
the meantime, salary can be
Salary they are being paid.
They're
You're
getting it,
paying
man.
your-
They're
you're
getting it. They're
your
drawing it.
salary.
for the past 4.5 months, madam.
That we will
That we
consider.
will consider. Now they are paying current salary.
Yes, they're drawing it.
There is no dispute. I'm drawing.
So now dispute regarding 11.
Only for 4 months.
2000,
Almost for 4 months.
4 months, 20 days.
Yes.
The grievance of the petitioner is that in spite of the direction passed by the learned tribunal,
Wait, please, Lordship. I am forced to open the innings.
Hmm?
My stalwarts and my friends are here. I must be to my prayer for correction of record order I refused on twofold ground. That is time barred and Town and Country Planning Act not applicable. Second ground is correct. First ground is not correct. Town and Country Planning Act is not covered by Services Rate Act. That is correct.
It is on 24th March, point of maintainability. Why you have come to us?
The question of the entire thing may be hard out.
No, sorry. We are not going into the merits of the claim.
Let the maintainability point be a special issue, and the entire my entire
That is what has been
representation will be
stated.
considered.
Mr. That has what been stated by the tribunal, that we are fixing it on
That is
that.
why, my lord, I am before your lordship that I have something more to say that they are with due respect, my lord. This conception of limitation is not correct. Because my lord,
Tell that to them. Your maintainability is open.
kindly leak that not, then I will be part from making a submission.
No. Why shall we decide that point?
No. Only thing I am asking,
Huh.
the entire matter will be hard out is making a special issue of maintainability.
That is what the tribunal has said.
Probably that is.
No. Kindly read the last line. Let the matter appear under hearing on 24th March on the point of maintainability. There is nothing, Mr.
There's some ambiguity in my thing, I think.
Where is the ambiguity?
Because accepting they have raised two questions of maintainability. First, the limitation one is.
Sir, we are not deciding the maintainability point. Tribunal is the court of
certainly
first
not.
instance.
Moreover, my lord, in view of the fact, my lord knows a larger bench is pending. On the
Tell it to the tribunal. Tell it to the tribunal.
Give us some opening to so that we can take other points also.
Whatever points you take.
But that is not the. I am confined to the maintainability only. Maintainability will be taken up. Certainly, maintainability will be taken up. I bow down to that.
What is your prayer before us?
So that the entire thing may be disposed of along with including the question of maintainability.
So from the order, what you are saying is what is appearing.
Only maintainability point.
So naturally,
I will depart from raising other points.
If the issue of maintainability raised, a court is to decide that issue first. If it is determined that yes, the action is maintainable, then it will go into the merits.
Kindly make that thing clear.
That is obvious.
If it is held that it is not maintainable, then he will not go into the merit.
Withdraw the application. Don't ask us to dismiss it.
Revenue officer. No, tribunal. Why tribunal officer? You have opted to go before the tribunal.
Otherwise,
withdraw that matter.
If I be
সরকারি আধিকারিকরা এটা নিষ্পত্তি করুক। No. 24/3/2025 ওদের কাছে দরখাস্ত করেছি। No.
But we have made a representation at P7. But three annexes are very relevant.
Sir, বলুন।
4, 5, and 7. We have made three representations. Two orders are there of the civil court and the writ court, and the representation is there. Those things will be kindly taken care of. While disposing of the maintainability point, I bow down to this. I can understand, my lord, but the difficulty is difficult to make this somebody else to understand. But what I can make your lordships understand.
Sir,
highest respect.
Why do you want us to dismiss the matter? Why do you want us to dismiss the matter? Withdraw, if so required, file preponement application. Matter is on March. It will be hard out.
But kindly, my friend, I something.
With the leave of my senior subject. We went to the tribunal against the inaction on the part of the respondent authority, government, which is permissible within the periphery of in the context of Land Reform Tenancy Tribunal Act 1997. The tribunal, it was not the prayer, that was made before the tribunal, that an inappropriate authority has been approached and they are not deciding the matter. The tribunal as a court of first instance, in view of the L. Chandra Kumar's case, my lord, the tribunal ought to have, my lord, disposed of the matter, directing the authority, because I'm losing the opportunity.
So
In
that's why,
24
Mr. Basu, we are not.
No, I am not saying. I am, my lord, the entire gamut of the order is under the, my lord.
Cannot
No,
go
no,
into the
my lord,
merit.
no, my lord, I am not asking your lordship to decide the merit, neither the tribunal.
Then what
Tri-
you are asking?
No, I am asking the tribunal on the first day, the representation made on 30th or 12th December 2022 and 14th March 2023. That was not, my lord, taken care of. Those applications were not taken care of. I approached the tribunal, my lord, for inaction, my lord. The tribunal ought to have disposed of the matter, directing the authority, my lord, to take call. Now, my lord, to dispose of the matter, instead of directing the matter, my lord, and recording the submission that will be decided, tribunal cannot decide the matter because, my lord, we are already armed with civil court's decree and the high court order.
Tell that to the
So, my lord,
tribunal.
today, my lord, I cannot, today, my lord, I have to wait for,
Sorry, Mr. Basu.
my lord, 24th March 2025. My lord, kindly have the charity to consider only one aspect. We are, my lord, we are armed with.
We have the charity. Your what is your?
No, my my lord, kindly sees, my lord, what is the, my lord, the High Court's order, my lord, daran ekটুখানি. 64, my lord, the High Court, my lord, said in the year 1989, my lord, I have two submissions to make subject to kind sanction, my lord. This is the order of the High Court, my lord. While we approach the
Basu, we
on the
fail to understand if the other side raises a maintainability point, you
What has
will
to be-
not allow him to raise.
No, I am not saying so. I said, my
That
lord,
is exactly
but
you're saying.
no,
that
my lord,
there was no necessity for the
No.
tribunal to accept that.
my lord, maintainability is a mixed question of fact and law. It's a limitation. I am well within the limitation after the amendment, my lord. 60 years is the time for correction of the record of rights. I said, my lord, the authority did not take the decision. The authority is the correct authority. So that, my lord, the tribunal, today, my lord, I have to wait. We are all senior citizens in the evening of our life. We have to wait for, please. No, my lord. My lord.
Up to that stage, it was very serious. Up to that stage, it was.
My lord, at least tribunal will be requested, my lord, to dispose of the matter as early as possible.
They come after vacation.
The only liberty I am seeking, requires kindly, that the honorable judges of the tribunal should hear us while
Only,
disposing
my lord,
of,
early disposal.
while disposing of the matter.
আমি তো বললাম আর কি বললাম
The learned judges may take care of annexes 4, 5, and 7. While disposing of the matter, learned honorable judges.
That is why we are saying you withdraw your petition. Why you are asking us to say that we do not find any reason to pass any order in this.
No, another thing is there, my lord. Another thing is there, question limitation. That is, now it is 60 years. And then moreover, it is, we are well within time. One of the ground of maintainability is the ground of limitation.
1 week
We
after
are
vacation.
very much within time.
1 week after vacation.
Yes, next. We would have dismissed it today, but as the vacation is nearing and you have been engaged,
And we wanted do not tax your lordships. But we are anxious to get it.
প্রিপনমেন্টের প্রেয়ার করলে একটু কনসিডার করে একটু বলতে বলুন
yes, next matter.
Number 7.
Even my lord, Mr. Mustafa in this matter, my lord, he engaged another court, my lord. Kindly short pass over, my lord.
He is seeking expeditious disposal of the hearing, my lord. The matter has been fixed on 27th of February 2025. This can be disposed of by granting him liberty to make a preponement application before the next tribunal.
It has been disposed of.
Contempt application, my lord, pending.
There is a contempt application MA
45, my lord.
MA 128 of 2017, arising out of OA 713 of 2016, which is fixed on 27th of February 2025.
My lord, law and pending, my lord.
MA.
MA.
Yes.
Connection is a disposed of original application.
My lord.
MA for what purpose? MA.
Contempt application, my lord.
Contempt application.
MA, my lord, misapplication, contempt application.
Oh, that means that part of the order has not been complied with.
Yes, my lord. Kindly see, my lord, page 45. Page 45. Tribunal called for the compliance report, my lord, on 18/5/2007.
We have filed a compliance report. They have taken out an exception to that, to our compliance report. For
What is, my lord?
my lord, this matter has been fixed on 27th of February for final adjudication of the matter.
What?
Eight years.
The order has been complied with or?
We have filed a compliance report.
Order has not been.
That has to be tested by the tribunal whether the order has
Every
been complied.
time, my lord, they are taking time on the plea that.
And they have filed an
There is some
exception to that.
instruction,
They have
some
filed an
instruction.
exception.
Since 2008, the matter is pending.
One page.
He has stated that
Alert
the
for the compliance report.
report has been filed before the tribunal. But that was not satisfactory. That was rejected. That will be decided by the time.
The bathroom.
That will be decided by the time. So your, that has been already, again, next date has been fixed in February 27. February 27, 25.
There was a direction for filing a reply, Mr. Siddiqui, on your part.
They have taken out an exception subject to correction before the net tribunal.
PLRO has forwarded a time frame.
Yes, yes, everything has been filed.
David in reply. Go and make an application for preponement of the date of
There. Formal. Yeah.
on the
Very
prayer
good,
of
our
Mr.
authority.
Mustafa Learned Advocate appearing for the petitioner, the present
আমরা মিস কেসে টাকা
the
ডিসপোজ
petition is
আমি জানি
disposed of
Put it
it,
down.
but it the petitioner to prefer an application, preferred an appropriate application seeking preponement of the date of hearing.
And in case of filing such application, my lord, they will take.
In the event such application is filed, same shall be considered in accordance with filed by the learned file. The same shall be considered
অফিস থেকে বেরিয়ে গেছে তুমি দাও
by the learned tribunal in
Since
accordance.
2017, my lord, they are every time they are
Needless
taking.
to observe. Needless to observe that in the event such application is filed
Within case. Since 17, my lord. Since 2000.
file an application for preponement. On your prayer, we have disposed of. On your prayer, we have said giving liberty to you to file preponement.
But in this matter, my lord, interesting question of law has to be.
Old submission and yes, Mr.
Not an interesting question of law has to be decided by the Honorable Court whether the existing pay of the employees can be reduced. Here, my employer is BSNL. BSNL fixes a particular scale for me on the revision. Now, the government of India compels BSNL to reduce that, whether that is permissible.
And your prayer has been rejected.
Yes, whether the Honorable Cat has rejected my prayer. Therefore, this question without deciding whether this can be done, they said government order, therefore.
Your reply rejoinder is annexed.
I think everything annexed. If a lordship fixes a date for hearing, I think it can be done.
My lord,
Question of
my lord,
law.
I am appearing on behalf of the BSNL, my lord. Factual aspect.
Your reply is there.
Huh?
Your reply is there in.
My lord, reply, my lord, factual is this is the second round application, second round battle, first round battle.
No,
The
no, we are not passing any
no,
order.
my lord, kindly, 2 minutes, my lord. My lord, BSNL create the post and send to the Director of Telecommunication for affirmation. Subsequently, BSNL paid the amount, the higher rate, my lord. My lord, the paper way application, Director of Telecommunication directed BSNL not to give effect. Then we stop the payment, my lord. Subsequently, petitioner filed an way application before the learned cat, my lord. Learned cat give direction to pass a resident speaking order. We have passed a resident speaking order and Director of Telecommunications pass a resident speaking order. And in my resident speaking order, which the
We are not hearing that. Why you are arguing that? This is, we have asked a question whether you have used an opposition before the tribunal.
That is annexed here.
That is annexed. And Miss Alam, you are appearing for whom?
For the Union of India.
You also filed an opposition.
I was just checking that one.
No,
Have you checked that?
I'll just check.
the তিনটে ম্যাটার আলাদা অর্ডার করে 8, 9, 10
No, no, they did not file as my instructed.
Okay,
because they
আমরা করিনি না?
reply, huh?
আমরা file করিনি। Then Lordship, if my learned.
Then you file opposition
I'll
to
file
this
an
writ
opposition.
petition.
Yes, Lordship. I'll file an opposition to the writ.
কতদিন নেবে?
Heard Mr. Bhattacharya, learned senior advocate appearing for the.
Submission 3 separate order, my lord. 3 cause of action is different.
But the same order, 9 and 10.
8, 9, 10, but
Yes,
separate order to think.
Separate order.
Hey,
is
Baba, yes.
Oh.
There will be thrice your name will be appeared.
No, my lord. Cause of action is that, but it is service matter, na?
Their problem is they will be missing fees. That's why separate the orders. চলো করে দিয়েছি।
Your Lordship, I am appearing for the petitioner, Your Lordship.
Yes.
The matter pertaining to Your Lordship expeditious trial.
Abar expedition. Okay. When has the date been fixed?
Date is 24th September 2024. Your Lordship,
Your 24th September. Day after tomorrow.
Day after tomorrow. 24th. No, my prayer is that Your Lordship pleading has been exchanged. On the last day, I submitted that. The pleading has been exchanged. Please come to page number 18, Your Lordship.
Page 18.
Page 18, Your Lordship.
Page 18, notes of arguments that has been prepared.
That has also been submitted, Your Lordship.
And their reply is there.
Their reply is there, Your Lordship. Written notes of argument exchanged, Your Lordship. Pleading complete, argument complete, written notes of argument exchanged. But after that, the learned judge transferred. New judge, learned judge came. And then come again page number 23, Your Lordship. 23. Again, it was recorded that the pleading complete. And the matter is at present now fixed for hearing, Your Lordship. Already 17, 18 adjournments has been taken, Your Lordship, but hearing has not been completed. My only humble prayer before Your Lordship, that date of hearing is on 24th September. Direct the learned tribunal to heard the matter. The petitioner is a physically challenged person and he is going to be retired in the year 2027.
What was the relief you prayed in the tribunal?
In the tribunal, there was a promotion pending, Your Lordship. In the year 2022, he became entitled for promotion, but he was not promoted. Subsequently, on the next year, departmental proceedings started, and in
No, you are still in service.
Yes, Your Lordship. In that 2027, Your Lordship. My only humble prayer, direct to take up the hearing matter. No, none of the hearing matters is being taken up in the learned tribunal, Your Lordship.
Filed in July.
Yes, your lordship.
Try your luck on 24th.
None of the hearing matters is I have no luck, your lordship. No luck. None of the hearing matters is taken up. In the only motions are being taken. It is 100% guaranteed.
100%.
100% guaranteed, your lordship. None of the hearing matters is being taken, your lordship. I am telling your lordship.
My lord, I am appearing. I am appearing for the respondent number 5, my lord. Under compelling circumstances, I am appearing and praying for. Hello, my lord. My lord, I am audible, my lord.
I'm there, madam. Probably he is not able to see.
My lord, my actual answering respondent is respondent number 4, my lord, and I am appearing for respondent number 5, my lord.
All right. ওনার নাম দিয়ে দাও respondent number 5. Respondent number 5.
Commissioner Central Excise.
It's for the Howrah division.
You are for 4 and 5?
No, my lord, I am for 5 only, my lord. Respondent number 5.
I am for 4.
So how can they engage?
What happened? They see the Howrah division has engaged separately. The main is not. Howrah division has engaged separately because he was there at this point of time.
Have you filed your opposition before the tribunal?
No, my lord. In this matter, I am only engaged for the High Court matter only, my lord.
Right.
Only this WPCT matter.
1, 2, 4 করে দিও আর 5 নম্বরটা অন্য। হ্যাঁ? You are only for 4.
No, my lord, I am for
Union of India.
yes, 1 to 4.
Oh, 1 to 4. 1 to 4 লিখে দিও।
I pray, my lord, for appearing online, my lord. I always physically appear before your court, my lord.
এক কথা বলে যাচ্ছি। 6 এর জন্য কি? South Commissioner.
I'm an advocate representing the petitioner submit that he is a physically challenged person. And he
আমাদের অ্যাপয়েন্টমেন্টটা কি?
approached the Islamic Tribunal not from the regulations of the issue regarding his promotion in 2020. And the parties have already exchanged their affidavit, and even after completion of
I can't be one.
even the written notes of argument also between the parties. But following the transfer of the judicial members of the tribunal, the matter could not be finally decided. And finally decided, he submitted decided. We have been informed that he submitted
Hearing completed ছিল না? Hearing তো মোটামুটি completed ছিল তো।
আপনার রিটেন নোটস অফ আর্গুমেন্টও এক্সচেঞ্জ হয়ে গেছে স্যার। পেজ নাম্বার 18 দেখুন স্যার। পেজ নাম্বার 18
আমি আগের দিন দেখিয়েছিলাম তো।
for hearing on 24th September 2020.
Written notes have already been exchanged.
Since the matter then
are not being taken up.
the matter is on the next week expresses apprehension that the matter would be listed on the date, but due to congestion in the docket, there shall be no possibility to take up the matter, and the matter would be again deferred to another day. ঠিক আছে? Having regard to the submission of the respective party and considering that it is it is submit that the respondents took adjournment at least on 18th occasion. But the matter has been adjourned at least on 18th occasion.
Respondent को the time নিয়েছে। My lord, respondent has not taken time. They have submitted.
No.
Was adjourned.
Matter might be adjourned, but not because of. My lord, my lord.
ঠিক আছে, এটা ওনার সাবমিশনের
Yes.
ঠিক আছে,
তুমি কি সাবমিট করছো রেসপন্ডেন্ট বলে দাও ভুল আসছে
to make an ঠিক আছে of the way on the returnable date that is on 24th September 2024 or as expeditious positive preferable within a period of preferably 8 weeks after the
I will. My lord.
Much obliged, your lords.
Much obliged. Well, my lord, I am for the petitioner. But I am for the petitioner. My original application before the learned tribunal was that service the item delivery confirmed to the addressee. Track item delivery confirmed to the addressee. So item delivery confirmed. Tag report says. I have.
এই তো ডেটটা দেখো না 19 নয়
one is 18/9, 1/19. ये तो चाहिए kindly comes to the impugned order the second page. My application before the tribunal was the prayer has been set out. A mandatory order be passed directing the respondent authorities for to take a decision on the applicant's representation dated 28th June 2010 being annexed as such and such. The impugned order second page. 22nd September 23. The first paragraph, the applicant has approached this tribunal under section 19 of the administrative act praying for the following reliefs. So my relief was only the direct the concerned authority to consider my representation. Now that that representation I have annexed at page 50. Now the kindly see the next page. Earlier occasion I approached before this learned tribunal and pursuant to that the authority rejected my prayer for engagement as a casual worker. Page internal page 3 the last paragraph second paragraph or paragraph 4 third line, engagement of a casual worker has not been considered as no casual post exists presently. So, thereafter, I filed application on 28th June. That is also recorded. Learned counsel for his engagement as substitute is the sole discretion of the general manager. So the the internal page 3, paragraph 4. Paragraph 4, the second part. Learned counsel for the respondent submits that in response to his application the application has been informed that his request for engagement as a casual worker has not been considered as no casual post exists presently. That is true. Now, learned counsel further submits that engagement as substitutes is at the sole discretion of the general manager and is done as per requirement. The applicant's suo motu cannot be considered under existing rule. Now, my application is pending, no decision taken. Kindly see the concluding part, the paragraph, the concluding part. No, that is the casual worker not at present. Thereafter, another application for the substitute as a substitute worker. That is the next line. It is stated. Learned counsel further says that engagement as substitute is the sole discretion of the general manager. That application page 50. This was initial prior to this.
Engagement as casual.
First time engagement for casual to temporary, that was rejected since there is no the post exists. And another circular is there for application. I can file an application for substitute engagement. That is the discretion of the general manager. Now, the next page, my lord will find the last paragraph 5.5.2. The applicant has also prayed for appointment as a substitute in terms of the provision of such and such is quoted below. These are the terms and conditions. That is the discretion of the general manager. The general manager did not take any decision. The learned tribunal. Now, before yes, that since the decision was not taken by them, let them. The general manager said, on that ground, I am not. That.
কবে থাকবে?
Next slide.
My lord, 13, my lord, I think, my lord, paper book has to be. Oh, my lord, I am for the appellant, my lord. Last occasion, my lord, I think, my lord, kindly hear out the matter. It's a very short matter. It's a only question of law is being involved. Whether if any public law element is being involved, then writ lies. Because the whole, my lord, the order, my lord, the impugned order, actually, my lord, implementation, my lord, direction for implementation of a, my lord, agreement, my lord, that has got no statutory force in the eye of law. Settlement. In the writ jurisdiction, my lord, so many, my lord, recent judgments, my lord, knows that. My lord, I have, on the last occasion, I have handed over one copy, the two judgments copy, a judgment copy টা যশোরের কাছে আছে এখন last occasion দিয়েছিলাম ও recent judgment of the Honorable Chief Justice follow actually the Honorable Chief Justice Division Bench followed the principle laid down in the latest Supreme Court judgment regarding what is public law, what is private law. So, my lord, I think, my lord, kindly pass an order, preparation for paper books, and my lord, kindly fix the matter.
Yes.
Everything is so, my lord, prepare.
Your reply? Have you filed your reply?
Reply.
So one thing, my lord, subject to question, what will learn?
Mark also.
Yes.
Reply.
Well, just a minute, my lord. I am checking. My lord, I think, my lord, it was not done, my lord. My lord, kindly.
My lord, one thing, my lord, I draw your lordship attention so far, if your lordship kindly takes up.
Oh, on the 9th, they have started.
If your lordship, I have drawn
My lord,
lordship, one.
kindly pass an order for preparation of paper.
But my learned friend is.
And my lord, hear out the appeal. This is a
Whether-
axiom. Yes, stay order here.
Page 20, if your lordship kindly consider page 20 of my opposition, where there is a specific letter written by the Puri municipality to the petitioner society regarding so-called notice for unsafe building situated at such and such. With reference to the subject cited above, I am to intimate you that the condition of the building, namely such and such, under your ownership is very poor and found to be unsafe for inhabitants of the local area. The building needs to be retrofitted or demolished as soon as possible to avoid any unpleasant situation. The state government is saying, as on this day also in occupation of the same.
They are not cooperating because they are the owners of the land. Unless my lord knows that. Sanction in whose favor? I just put that question to myself. Sanction in favor of the owner. They are not cooperating.
It is not that.
Well,
they are
hand
acquiring
over.
my property. So, in the meantime, if something happens, the state of West Bengal will take the responsibility.
My lord, on the one hand,
no, they are forwarding this letter to us. They are forwarding this letter to the respondent, the president of the respondent hearing. So, yes. Now, my lord, it still remains with the. Yes. So, in the. I am not in position. The government is in position. That is why it was directed to return the property to the private respondent. And the. Yes, the building which belongs to this respondent, which was given to the government with the condition they have to do these things, otherwise you will return the same. The government and admittedly did not did anything, only retained the position of the same. That is why it is not an acquisition. Because there is a direction page 20, even Lordship can turn to page 20 of my opposition, which was there before the.
Puri municipality.
And the person who was elected by me, now my lord taking that.
No, I am not.
I'm not on that.
My lord,
Page 20 or 6.
Kindly, unless my lord, the sanction building plan has.
My lord got it. Page 20. 22. That is what bought. Charles says it was bought before the time, and his the honorable single judge was please obey that. I will dispose of the matter, so I take any stay. I'm not passing any order to that aspect. Now, if the matter is pending for some time, says my lord, down the ready, it is in such a condition, my lord, it can be pulled out and as your lordship. Yes, my lord. I am grateful to your lordship. Yes, my lord. Only for that reason. If my lord knows better than me, Mr.
My lord, within a week, my lord, I will try. Because 9th they have had. My lord, instead of first October, no, first October.
কি হয়েছে? না,
This will be that.
Other than order, so please ask your.
No, 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 no. Yes, yes, yes. No, 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 no. Personal difficulty. No, no. Cannot be it. My lord, actually, personal difficulty, my lord, 30th and Act to first of
as your lordship. As your lordship, please, as well. I'll come back.
my lord, I think, my lord, on the next date, my lord, kindly hear out the everything. My lord, this is by very short matter. Very short matter, my lord. If I lose, lose. But my lord, very short matter. Of like, may I leave, my lord?
Lord, I'm for the state respondent.
I'm for the appellant.
The appeal against the, my lord, the contempt application.
Yes, my lord.
Yes.
And next Friday, my lord.
Judge sir, conveniently করে দাও না.
Next
After vacation, my lord.
Next Friday.
Next Friday.
আসুন, আসুন। Contempt.
14, my lord, the contempt arises, my lord.
Judgment.
Contempt. Yes, my lord. We have
Justice সৌগত ভট্টাচার্য।
Mr. Bhattacharya appeared, my lord. Yes. Judge sir, convenient. Judge sir, পড়তে দেন।
My lord, your lordship kindly take it up on next Friday, my lord.
As you.
I am appearing for the respondent.
My lord, I am for the petitioner led by Mr. Roy. Is the contempt application on 18th of September 2017. My lord, your lordship along with Justice Nishita Matri passed an order.
Contempt now.
Yes.
Contempt now. And order, as per order, control authority already comply the order.
Paragraph 23, 24.
Oh, what? Yes, my lord. My lord, out of 5 petitioners, 2 was retired, 1 was expired. Now 2 is left.
Who is working?
They are still working.
Still working.
My lord,
From Banerjee.
Gautam Banerjee retired. My lord,
And Gautam Banerjee already retired. Yeah, kindly, my lord.
আরে আমার নাম গৌতম
Oh,
বলে
আচ্ছা,
সেই জন্য
sorry,
বলছি।
Who died? Who died?
My lord,
High time, Mr. Banerjee. Retired.
my lord, so far serviceman is concerned, my lord, he has retired.
Scheme formulated.
No, till date, no scheme has been formulated.
You are getting your regular salary.
My lord, only, my lord, we are the kitchen.
Oh, he knows everything.
Ali Mala already formulated the post. Already he joined the service. Already salary withdraw the salary till now.
No,
till date.
we asked you to formulate a scheme
Yes.
for regularization of the canteen employees.
Already regulation.
Regularized?
Regulation already.
Your lordship kindly give directions to show the regularization later.
Right, you file an affidavit. File an affidavit enclosing the documents.
And saying that they have
Present contempt
formulated a
application.
scheme.
আরে সেটাতেই ওই এফিডেভিটে তো
Has
সবই
to-
থাকছে
Where is your affidavit of service?
এভিডেন্স সার্ভিস
Pursuant to
Including whether a scheme has been formulated or not.
That is the order. We have said contempt application, you deal with that awardments.
Grateful. I'm grateful. Grateful.
Grateful.
My please, Your Lordship. Madam, for the petition. Here, my lord, we have alleged contempt, my lord, of the solemn order, my lord, passed by the Honorable Division Bench presided over my lord Justice Matre, as his ladyship, my lord, then was, of which is at page number 42 in the contempt application.
Pen drive party. Pen drive. Huh? Which order?
Page number 42 of the contempt application. My lord, the order dated 12th of September 2017. But this was carried before the Honorable Supreme Court. And my lord, the Honorable Supreme Court was pleased to, my lord, dismiss the special leave petition, along with all other matters from different corners of the country. So, my lord, after this, my lord, even in spite of that,
the Supreme Court decision 23.
yes, my lord, page number 45.
Yes, then what happened?
After that, my lord, after that, my lord, it was not complied with, my lord. We filed this contempt application, and after the first hearing, my lord, it was communicated to the alleged contemptors. We have been, my lord, given with office order after that. Your lordship will kindly seize this.
Lordship, thereafter, a review application was filed against the order, Lordship. And
That was
in July 2024, that was dismissed. Thereafter,
July 24?
the review application was dismissed by the Honorable Supreme Court. Thereafter, we have
review of the Supreme Court order.
Yes, Lordship.
Oh,
Therefore, thereafter, Lordship, we are processing the payments, Lordship.
You're
We have already
processing.
started. Yes, Lordship. We have already started that. Therefore, Lordship, if your account fixes a date after
I
vacations,
it was preferred against this order of
Yes.
7th November.
yes,
And
Lordship.
that was
Disposed of on the
disposed of
dismissed on the 16th of July 2024.
16 July 24. Thereafter,
Thereafter, we have started.
file.
Yes, Lordship. Thereafter, we are processing the payments, Lordship.
And
So you file a compliance.
I
report?
shall, Lordship.
Lordship,
Lordship
could
will
be-
kindly keep the matter after
dispose of
vacation. Now, Judith,
if your lordship kindly seize the order once.
we've decided to implement the order. Then, Lordship, I'll file an yes, that is my instructions also. But maybe they have not been paid as yet because it's too.
No, not-
I mean, it's not yet time. After vacation, maybe I'll be able to report that as well. ওটা দিলে?
এটাই দিবেন। ও দিদি, হ্যাঁ, আপনি রাখুন।
হ্যাঁ, ছুটির পরে রেখে হয়তো তার মধ্যে দিয়ে দিলে আমি কমপ্লায়েন্স দিয়ে দিতে পারবো টোটালটা।
How can your officer say this, Miss Allah?
Lordship,
that it will not be treated as a precedent?
Well,
Lordship will. Lordship, that is something that I am
The
also not.
principle of law has been laid down. That will certainly be a precedent.
Lordship.
And how can an executive director of the railway board interpret the Supreme Court judgment?
Yes, I was waiting.
Then we shall place them above the Supreme Court.
Lordship, let me report the compliance, Lordship.
This is audacious.
They have started. I shall get back to them and convey your Lordships.
Yes, how can you
I
write this?
shall
This is
definitely
no
do
vote of
that.
contempt.
I shall definitely do that. I shall definitely do that. Lordship, and Lordship keep it after vacations, Lordship. I'll be able to, maybe by that time they'll be getting their payments. I'll be able to report.
Present contempt application has been preferred. Challenging
My position, Madam, for the petition.
Item number 17 and 18 kindly be taken up together. I am appearing in item number 17 on behalf of the alleged contemner, and at the same time, I have also filed a review application, my lord, with a section 5 application.
You are in 18. You are in
17 and 18 in both. In 17, I am on behalf of the alleged contemner. I am appearing with Mr. Rajiv Ray, and my lord, in 18, I am appearing in I have filed one review application with a section 5 application, my lord. So both these two
appeared.
Yes, my lord. Initially he was appearing. Yes, my lord. Today he is not present, my lord. I am coming.
He is not there.
Yes, my lord. He is always there. He is the. Oh, he has retired from the. He has retired.
Yes.
Oh, that matter that you gave.
Kindly
Kindly
take up alert first.
Order and thereafter you have paper.
My lord. My lord, initially what happened? Order was passed on 20th of December 2023. The alleged contemner, my lord, the Additional Central Provident Fund Commissioner, duly sent communications to the central office. Subsequently, few documents were surfaced, from which it is seen that from the very beginning, since 2014, the petitioner, the writ petitioner, she has suppressed few documents. That's why, my lord, he will not come within the financial penury. That is our case. These documents were surfaced
after your SLP was dismissed.
My lord, not that, my lord. I bow down before your lordships, not that, my lord.
Read the order.
My lord, I know, my lord. I bow down.
Mr. Gupta appeared.
Yes,
we were very annoyed with the conduct.
I know, my lord. I bow down. I bow down. But fact is not
But
that,
if
my lord.
he had taken
We have some
personally-
documents, my lord.
But if he had taken so personally and retired from the matter, it is very unfortunate.
My lord,
in that case, Mr. Mukherjee, we cannot even show annoyance as regards a deliberate, as regards deliberate sidetracking of the order of the court.
My lord,
If
what
we
happened-
ask the advocate
My
that,
lord.
sir, how you could have, because he was not there on the first occasion. So we requested Mr. Gupta, have you seen the earlier order? So he went. He said that there is a change of advocate. I have been engaged afresh. So I said, all right, but Mr. Gupta, this conduct of the officer, he could have come and told you that this was the previous episode.
My lord, I have gone through the documents, my lord.
And now we find that when he then requested that, all right, my lord, I have been subsequently engaged. You keep the review application along with this. I said, why you are taking this adjournment? And now, since we have asked the officer, we have expressed our annoyance, the person retires from the brief.
My lord, I bow down. But the fact is, my lord, it has no connection with the dismissal of the.
We are not annoyed for any other reason. We are annoyed at this conduct that the advocate who came here to represent the alleged contemner stated that step has already been initiated to comply with the order.
Well, that is true, my lord. It was already our process was initiated, and we have the documents that we have did our communications to our central office. Thereafter, my lord, central office sent some documents from which it is surfaced that they have suppressed the material facts that they.
When did the first document surface?
My lord, documents surfaced.
Tell us the date. When did it surface?
My lord, actually, since 2014, when, my lord, we sent the pro forma to for their filling up, they said a particular column that they do not have any immovable property. They said no. Subsequently, we came to know, my lord, much later.
When?
Probably in 2024. In 2024, we came to know that they are.
Right. Your officer came to know in 2024?
Yes.
An advocate was representing the officer. He could have told it us on the first date that, my lord, this is the fact situation. Kindly allow me to bring the document. We asked him. And there was a specific statement that as SLP has been dismissed, we will comply with the order. We thought that he was not on instruction.
Subsequently, my lord, through one email we received on or about September, 6th September 2024, therefrom we came to know. My lord, I can show.
Email from whom?
from our central office.
So central
Head office.
authority is not a party to this proceeding.
No, my lord, they said that
Central authority is not a party.
in this case,
He is a party.
my lord, additional Provident Fund Commissioner. Central office the party chilo na?
Yes, yes.
From the very beginning, central office probably they were not.
Yes, yes. Yes, point number 1 and 2.
Number 4.
1, 2.
Number 4.
So your defense goes.
No, my lord. Yes, my lord, Chief Provident Fund
No,
Commissioner.
we are worried about this conduct of this person. You ask him to come.
My lord, my lord,
You ask him to
my lord,
come.
my lord.
No, let us hear it from him.
My
When repeated advocates are changed, tomorrow you may also be changed.
No,
Who knows?
my lord, kindly appreciate one thing, my lord. I have filed a review application.
This is an audacious conduct, if I may say so, that misguiding the advocate, making a statement to come out of the regards of contempt, and thereafter repeatedly changing the advocate at his choice. At the drop of his hat, he can do so. You ask him to come. We will ask whose money he is utilizing.
My lord, may I
No,
humbly say-
this is a serious issue.
My lord, I bow down, my lord.
We always see that our officers are not embarrassed. We will not allow a person to embarrass you.
My lord.
But what is this conduct, sir?
My lord, may I humbly say one thing? My lord, we have
You ask him to come.
My lord, kindly appreciate one thing. We have filed one review.
Why he will not come? Let us know.
My lord,
Why he will not.
I bow down, but my lord, his personal appearance was not there, my lord.
We will ask him now.
Kindly do not, my lord. Kindly appreciate one thing. Kindly allow me to submit, kindly allow me to place my review application along with section 5. If it is admitted, then all right, my lord. If it is-
Review is a separate jurisdiction. We are in contempt.
My lord,
Contempt, review filed, SLP filed, appeal filed, no stay order. We have every right to proceed with the contempt.
we have,
Every right.
my lord, we have duly communicated. Kindly seize our communication orders, my lord. Probably.
So then tell us that my hired officer is not doing anything. This was also the submission. On the first day, what happened? First day he said, we asked him that this is your, he said, my lord, he's Assistant Provident Fund Commissioner. He has also written to his superior officer, and we are just awaiting the sanction.
My lord, fact was that, my lord, we communicated, and my lord, we have the documents of those communications. We have duly communicated regarding your lordship's last order. Subsequently, that document surfaced. Our duty is, my lord, to bring those documents before your lordships. We have communicated. Kindly seize our communication letters, my lord. Kindly seize. We have duly communicated. My lord, probably on the last occasion we have filed. Kindly seize our honest intention, my lord. It was not a willful and deliberate violation, my lord. Not that. Kindly seize. We have already.
So what is the present state? Are you in the midst of compliance, or you have already taken
My lord,
a decision?
if your lordship sees this document that he is already having a immovable property worth more than 40 lakhs, thereafter, if your lordship says that we shall comply, my lord, kindly seize our intention. Kindly seize, my lord. We have sent our documents. The alleged contemner.
This you have annexed to your review. This you have
We did not get opportunity. If your lordship says we shall file, my lord.
Why shall we say?
My lord,
is your child.
All right, my lord. We are, my lord, sir. We shall submit these documents before your lordship. Kindly goes thereafter as your lordship pleases. It is not willful and deliberate, my lord. Kindly seize these documents. As soon as your lordship passes the order, we have sent the communications to our central office. My lord, thereafter, they got that document. That from the very beginning, they have suppressed. They, this petitioner, he is having a immovable property worth more than 40 lakhs. From the very beginning, he had suppressed that.
You have got this document or information after filing the review application.
My lord, before filing the review application, before
So you have proved this ground that he is financially sound for having immovable
we did not know, my lord. We did not know.
So what is the ground for seeking review?
My lord, as soon as we received that document showing that he is having immovable property.
In your review application?
In my review application, I have already said that. I have said
রিভিউটা
Yes,
আসেনি?
first ground, paragraph 1, first ground. Relevant grounds are 1, 2, 3, 4.
Where is your application in connection with this?
Review application.
No, you have to file a miscellaneous application for stay
My lord,
of the order.
yes, my lord, stay application we could not file, but only file review and section 5. If section 5 is allowed, my lord, we shall file the stay application.
Oh, then you will get another 2 months time.
My lord, question does not arise, my lord. Question does not arise.
Oh, he's very concerned about it.
My lord, question does not arise. Kindly seize my ground. If your lordship satisfied, then all right. Kindly seize my grounds.
Who is the contender, Mr. Roy?
My lord, tell your lordship, my lord,
Additional public, additional
my lord, the content.
Additional Chief Provident Fund Commissioner.
I'll just pray your lordship's leave so that I can add the central office as a contender because to your lordships in the contempt application. Since it is the stand that because of this departmental paraphernalia,
No, this is
they
not
could
my
not taste.
stand. This is not my
I just
stand.
pray your lordship's leave so that I can add these gentlemen as a party. I'll
This is
just
not my stand.
beseech your lord,
But I have received the documents therefrom.
including the secretary, my lord.
How you have filed the contempt? Where is the name of the alleged contempt?
My lord, your lordship will find.
You are Tuhin Chakraborty and Ratna.
Yes, mother and son.
This is WPCT contempt.
And my lord, page number 6.
Contempt application to go there.
Only one.
Yes.
Raju Bhattacharya.
Yes.
Additional
Provident Fund Commission. I pray your lordship's leave so that I can file, my lord, 2 more. I just add the name of 2 more alleged contemptors because it is coming out that because of them, my lord, the orders are not.
I'm appearing on whatever.
Let me just praying for a leave so that I can do that.
Not being able to comply with the order in
My lord, I have
absence of,
complied.
in absence of approval from such and such authority.
My lord, I have complied.
So that authority is standing in the way of.
My lord, not that.
Great.
Not that.
May I
my
just
lord.
do
That is not my submission.
So
My lord,
we
I
are
have
thinking
received
that
the
person
document.
also.
That's why I have come before your lordship. This document is new, sir.
We will scrutinize the document.
My
You
lord.
tell us who is your superior officer.
Or I have got the name, my lord. I'll just pray
Who
for you,
is this person who is standing on the way?
Lord.
Not in the way, my lord. That document we have collected, we are placing that document before your lordship.
Just show us the document.
Yes, my lord, kindly seize the ground, my lord.
No, this document you are saying.
These are the instruction, my communications, my lord.
This is not on record. How can we take note of that? That is not in an application.
Not in an application, my lord. In an application form, we shall submit.
Yes, that is why I ask him to be here before us. But you take steps for filing your application, we will hear. In the meantime, he will implement the other contender survey notice and
My lord, kindly allows me to serve the section 5 as well as the review. Thereafter, my lord, if required, my lord, kindly seize my ground once, my lord. Kindly seize my ground once. Ground number 1. Kindly seize, my lord. Kindly seize.
Secretary नाम तो क्या?
Third line onward.
just. Now you have acquired knowledge where is the, how you have acquired knowledge that the petitioner has suppressed? Where from you have come to learn? First ground which you are asking,
My lord.
you say that the applicants acquired knowledge that he had suppressed possession of property by incorporating no in the column in respect of a declaration of the year 2014. So where is that document by which you acquired knowledge?
We have the document wherein they have stated that if he is having movable or immovable property, there he said no.
Yes.
And my lord, if any other assets are there he said no.
Very good.
Yes,
So
that document
when did you get that document in hand?
we
That,
have we have my lord, we have collected these documents since 2014, but in the year 2024 we came to knowledge that he is having a property.
Was there? Was that letter the 2020? This is the letter by which
No, but this is a document of 2014 wherein it is shows it is seen.
No, right. We are understood that if he had more immovable property, why should he write no? That is misleading. Now, when did you acquire that knowledge?
That he is having property.
Huh.
So now that instruction I have to take when and how.
Very good.
When and how.
Then ask him to come. You ask him to come.
Not required. My lord, kindly appreciate that I am taking instruction from him, and this is my duty to place before your lordship.
No, we don't understand what sort of an officer he is that he is not coming before us.
Well,
Why he is
if
so
required,
afraid?
he will come, my lord. If required, he will come. But there was
No,
order.
why this sort of, it is not clear to us why the officer of the government does not want to come to the court. They think
My
that
lord,
it is a
there was
insult.
no order, my lord. That's why he is not coming.
Ask them to come due to their failure to act properly. Is so much cases is going on against the Union of India, against the state of West Bengal.
Oh, sir. Did you meet with your client?
My lord, I met with my client, yes.
You met.
But my lord, this question I did not ask. How I have seen that from their they have came to know about their property, but how they have acquired this knowledge, this I did not ask. I can ask, my lord, I can ask how they have acquired this knowledge.
One screening committee was formed.
Has he given you fresh wakalatnama to your advocate? Where is that? Have you filed it in the department? What is the number? Tell us.
On 18th September, bill number 5.
18 September.
তারপরে এই কার্তিক
এই এটা কবে শুনানি হয়েছে? অর্ডারটা তো শুক্রবার ছিল।
Kindly see the last order dated 10th of September, probably 10th of September.
10th of September.
Sorry, 22nd of August. 22nd of August.
Is it a fact, Mr. Roy?
My lord?
Is it a fact?
About the property? No. No. But about the property, no, it is not a fact.
You had a talk with your client?
My lord, no, I did not have a talk. But previously, when we were doing this matter before this honorable court, I specifically asked these questions to them. They said that.
That means this question was raised previously.
I asked them that what about your financial position? So I cannot, my lord, apprise your lordship, my lord, the financial condition of my client.
He's
No, did you get the particulars of the property which they have
he
referred?
did not even serve the review application, anything.
Did not get the opportunity. That's why I'm.
Review also you have not served.
My lord, there was just my lord, today it has come for the first time. That's
No, it appeared last Friday. There is a big episode,
my lord.
You have not been apprised.
My lord, there was no direction to serve. That's why I did not serve, my lord. There was no direction. Kindly seize the order.
There was a
Mr.
finding
Gupta
committee.
appeared. He said, keep it in the next week. I have filed a review. I told him, when have you filed?
Yes.
So initially we understood that it was filed 2 days earlier to Friday. But when the matter was becoming tense, he said that this is my slip by which I have filed the review. And that was of the self-same date. So on Friday when it was heard.
Hereafter it has come, my lord.
So you ought to have served.
My lord, grateful,
Your
my lord.
junior was there.
My lord, hereafter it has come, my lord.
Now you have not filed an application also in connection with review.
Kindly, my lord, grant me leave so that I can add, my lord, the respondent number 1 and 2, my lord, at the alleged contemners to your lordship. Because they are standing in the way, my lord. Because these are the facts. As per order 47, they cannot even take this.
Lord, how can you say that
They cannot
they are standing in the way?
take all these points right now before your lordship. Because there was a fact-finding committee.
Section 5. That is you have filed.
Filed for your lordship. Section 5, my lord, can 1 of 2020.
My brother has a bench. Please come at 2 o'clock. You would be there.
My lord, can I humbly pray for one thing, my lord? I am serving in the meantime, my lord. Thereafter, we are coming back.
I
am
may
serving
be
the section 5 and the review
them as a
application.
parties. Kindly, my lord,
But
can't be.
presently, I feel not required as your lordship pleases. But my lord, my humble submission is
now.
I'm praying to your lordships, not to my learned senior, my lord. I'm praying to your lordships, my lord, so that they can be, my lord, added as a party.
In the meantime, I
So
shall
this has
also
come
file
because this is
an
their mail.
application also, my lord, stay application. Kindly give me liberty also. I shall serve
Yes,
all
of
the
course.
copies to my learned brother. Thereafter, my lord, we shall come.
And my lord, kindly also, my lord, grant me with the liberty because he cannot basically subsist right now. They are just dragging this matter day by day. Lordship, kindly grant because they are the person who are sending them the letters,
Thereafter.
mails.
If the question is if we add them, we have to bring this on record. That he is standing in the way of non-compliance because our order was you give compassionate appointment.
My lord.
So let us ascertain this whether this acquired knowledge was acquired.
I shall, my lord. I shall.
Go through that and we will dispose of the review and take up if we
Grateful, my lord.
if we
As your
set
lordship-
aside the review. we
As
will-
your lordship, please this one. Only, my lord, I'm not requesting your lordship, my lord, to record that they are standing in the way. All I was just suggesting before my lord that they are the respondents already in the writ petition. So, my lord, now it has already come to your lordship's notice that this is the mail.
To a prima facie consideration that this is the authority who is standing in the way. So he should be brought on record. Our order is not being complied with because the obstruction is being created by this person. Then we shall be able to proceed against that person. So we have to record the
Lordship, my lord, kindly in that event, my lord, kindly, my lord, post this at 2. Kindly, my lord, request your lordship
I shall serve
to post this at 2. Kindly, my lord, post it.
or not, they don't comply with
or such
My lord, kindly post this, my lord, at 2 in that event, my lord. Lordship will kindly cease. I can, my lord, satisfy on law only, not fact.
Give the property particulars.
My lord,
That
Then you have
property
to assert
particular.
it.
my lord, I shall give my lord.
Because he has
application I
No,
shall
no, we will ask him
He can
to.
take this point now.
What
Order
is the
47
prima
part.
facie reply? Let us see. Do you know where the
Review
property is?
application there. No, my lord, I do not have any idea, my lord. I shall take instruction, my lord, regarding that.
Then
Let me
come
serve-
back at 2 o'clock.
Great.
My lord, may I be permitted to mention that
Not mentioned.
the 12:30 fixed matter, the item
It will
number.
be there in the list.
May I permit on item number 15. Item number 15, kindly correction, kindly, my lord. Affidavit was given to the respondent number, contempt number 3 will be 1, kindly, my lord.
Why he is the deputy secretary? He is the secretary of the concerned department.
My lord.
Let him first come with an evidence.
Kindly, my lord, item number 1, kindly, my lord, contempt number 1, kindly, my lord, very direction. The director of the National Institute, kindly,
The secretary. It will be
the director. Will be correction. Contempt number
Direction upon 3.
direction upon you, kindly, my lord.
Being the secretary.
Secretary. Kindly, my lord, secretary Delhi, kindly, my lord. On
Call
behalf of
Mr. Banerjee.
on behalf of
Call me your who appeared for the petitioner. Call him.
I inform you, my lord.
No, information. Go and call him.
Okay, my lord.
Then we, yes.
My lord, item number 60 actually prayed for this adjournment for 1 week. Mr. Chakraborty came.
Let it remain in the list. We are 12:30 marking will not appear. If it is reached, you remind us that Mr. Bhovik is there. He mentioned in the morning, saying that please keep it next week. But as you were absent, we did not say at that time.
Only if it is come after puja vacation or what, I don't have any objection.
All right, let it appear not this week. Kore rakho. Let it appear next week as he has prayed. We will.
My lord, before going deep into the matter, my lord, I had a talk with the authority concerned, my lord, and they have said that we have taken a point. This has been surfaced. My lord, kindly allow us to serve a copy. My lord, if my application is rejected, my lord, we shall obey whatever will fall from your lordship. We shall not be the bar in between, my lord. Kindly appreciates this has surfaced. My lord. No, my lord, not disobeying, my lord, not disobeying. My lord,
no, Mr. Chakrabarty, it is happened. Single bench passed the order, contempt proceeding initiated, then said, yes, we have prepared that. First day after the receipt of notice, they come, we have prepared the appeal or review. First, if anyone comes, yes, we are taking steps to comply with the order. And on the basis of such submission, order has been recorded. Thereafter, if we come,
my lord,
we have filed.
My lord, the authority started taking steps, my lord. They started taking steps. My lord, may I humbly state, my lord, one thing? I understood, my lord. I bow down, my lord. I understood, my lord. My lord, kindly do not embarrass him, my lord. Kindly do not embarrass him. I am appearing, my lord. Kindly do not embarrass him. He's a very senior lawyer, my lord.
I call him. Yes, my lord. Yes, my lord. I have said. Yes.
Lord, is it required, my lord? I'm asking, my lord. I asking myself, my lord. He's a senior, my lord. He's senior to me, my lord. He's senior to me. My lord, kindly appreciates the embarrassment, my lord. He's senior to me. Yes, my lord. He's very senior, my lord. Your lordship knows everything. How can I appear then? I can assist him. Yes, yes. My lord, then my lord, kindly. No. My lord, kindly record my submission that I had a talk with the authority concerned. They said they are not in between, my lord. They will follow whatever will fall from your lordships. We have taken a point. My lord, this is true, my lord. The investigation team, they have inquired and they found that he has got a flat worth more than 40 lakhs from a promoter, and now my lord, how he got the flat, whether that was the probably, my lord, they had a joint property. That property was given to the promoter and therefrom he received a flat. But this, whatever I received, be that as it may, my lord, I do not go deep into the matter. I shall serve copies upon him. Thereafter, as your lordships pleases. Thereafter, as your lordships pleases, we shall follow, my lord.
My lord. My lord, may I request your lordship, my lord, to see page number 55 of the writ petition once? Of the writ petition. মোটাটা দেখুন, মোটাটা writ petition. Yes, is an annexure of the writ petition, my lord. Yeah. My lord, may I request your lordship, my lord, to see 1, 2, 3, 4, fourth column, my lord, row from the bottom. My lord, it is a form, my lord. Has my lord got that? It is disclosed. It was considered by them, by the screening committee. They have recorded in their screening committee report. Then once again, my lord, kindly follow my come, my lord, 61. My lord, this is the column. This is the column, page 61. Yes, page 61. My lord, third line from the bottom. The third row from the bottom. Movable, immovable property. Other properties, no. Then kindly, my lord, come to page number 70. Kindly comes to my lord, page number 70. All of them, my lord, everything is taken into consideration by the screening committee. ওই ভালো পেপারটা
Then, my lord, kindly 69, my lord, kindly see 69, page 69.
Fine.
Page 69. Clause 4. We live in a rented house and it's very difficult to both 69, my lord, of writ petition. Paragraph 4.
Before his death.
Before his death. Before his death. It starts with before his death. And in the bottom, in the last paragraph, last line, we live in a rented house. This is their submission, that they live in a rented house. Yes, presently, which he did not state, did not disclose. My lord,
Page number 70.
my lord, again I am
70, my lord. My lord, let me just, my lord, get the leave so that I can add, my lord, the respondent number 1 and 2 as parties. Because
my lord,
I tell your lordship, may I make my request before your lordship?
Question of if it arises, then you can. It does not arise, then that is.
My lord.
Why you are here?
My lord, no, my lord, I have been instructed not to appear in this matter since my learned friend has been engaged. My lord, as per instruction of my client, otherwise, my lord, I have been told why you have appeared. My lord, since my learned friend already
I
been
am
engaged.
here, my lord. He is a
No,
very
no, no.
senior and respectable person of this honorable court, my lord.
That's right, my lord. But my lord, later I.
Contempt matter, we, although it should not,
My lord,
we become
my lord,
to some
as
extent
per
hard,
instruction.
but not to the advocate, but to the person standing behind you.
But my lord, I have followed the instruction of my client, my lord.
More than, I believe more than. Mine is 26.
Yes,
Yes, my lord.
since
Mine is
83, I am
26.
practicing. Since
He is
83,
very
I am
senior, my lord.
practicing in this unrolled court, my lord. I appeared about 40 years.
But I was just requesting your lordship to avoid further delay because on the next day, because your lord.
Knowledge consequently that you are owning.
My lord.
On another officer is standing on.
Then I follow my lord.
But they says that that is not a case. My sole ground is of the
This. And my lord, this.
determine that.
As your lordship.
Order will be complied.
As your lordship.
My lord, this should be recorded, my lord, that if I am not unable to satisfy your lordship, we shall follow every direction from your lordships, my lord.
On last occasion, I have submitted say.
My lord, my lord. My lord,
Same submit.
not required, my lord. My lord,
Yes, sir.
yes.
Well, let's. Yes, sir.
Your name would be recorded, and if one let
Don't take him abyss.
Grateful, my lord, grateful.
But my lord, my respectful submission, keep this matter after vacation. Because after vacation, because my lord, during vacation I shall be, and before that, my lord, kindly, 1 week nothing. But my lord, kindly keep it.
Request গুলো করবেন না স্যার।
Let it be after vacation, my lord. I shall also file the application, my lord. Let it remain after vacation.
That's why I am praying for. My lord, I have instructed my client also.
when the decree was passed.
Account for repair at the time of hearing, you will take this plea.
Because there is no such submission to that effect, to your lordship.
Appearance, my lord, as per my lord direction, I appeared.
He's too senior.
That's why, my lord, otherwise, because I have been instructed not to appear. That's why I am praying for, my lord. By later dated, my lord, I have.
Yes, my lord, I shall inform.
My lord, one line kindly add, as per my lord direction, I appear.
Rajiv Rai.
Grateful, my lord.
Yes.
Yes. My lord, of course, my lord. My lord, right now I am saying, my lord, they are not the path. Grateful, my lord. Grateful.
My lord, Mr. Yes, my lord. That's why, my lord, anti-analyst direction. Otherwise, my lord, pardon. My lord. Otherwise,
Mr. Gupta is too senior. From the very beginning, my lord, we have learned from persons like them. Yes, my lord. Yes.
Yes.
Absolutely, my lord. From the very beginning, my lord, we have learned. We have learned from persons like them. Always.
Say that.
Grateful, my lord.
My lord. Yes. All right.
অভিজিৎ অভিজিৎ মিত্র
Honor 15. এটা 1 নম্বর হবে।
ঠিক আছে
I am appearing for the respondents. Well, we have already complied the order.
No, that is not.
Yes, I am satisfied.
Yesterday, my client received one letter dated 10/9/2024, my lord, that is not fully complied.
I am. We have already issued an office order that the money will be transferred, arrears amount will be transferred to him, and a part has already been received by him. I do not know whether he is properly instructed or not. This is the office order.
Copy?
Yes.
That copy I have not, sir. They have served me one letter, my lord. For 1 week time may be given, I have to take instruction.
And my lord, may I
whether they
hand
have
over
served,
another?
they have disbursed the amount, whether my client have received the revised PPO, they have
No,
to
he
issue
has
the
received. This is the receipt.
কোথায় দিছি কি রিসিভ হয়েছে কখন রিসিভ করবে এখনো তো ফোন করলো
The past for rupees 32,672 has already been disbursed at the bottom portion. Less deduction 0, net amount payable 32,670.
there is a recovery of 1,50,000 that has to be, there is a direction that to be,
That is the
I'll
rest
take
amount will be
instruction.
paid within a few days. I am saying it upon instructions. This amount has been disbursed already, and the rest will be paid within few days.
So we will record that.
My lord.
Sub affidavit, yes.
My lord. My lord.
In the meantime, you take
Take instruction.
and take instruction.
I have handed over.
এটা আজকে দেখাচ্ছি বিল No, no, I'll talk to in morning, my lord. They have said only. অ্যাকাউন্টে দিতে হবে
Before puja, another instruction is required.
No, no, no. Perhaps, yes, not annexed. This is the Supreme Court. কেন দেখাচ্ছে না কোনো জায়গায় কোথা থেকে দিল এটা তো 19/2000
Out of record, I am saying this that they sought
এইটা
opinion
ভুল
from
আছে
me.
1983
I opined for filing a review, but thereafter it was decided that no, the money was to be disbursed.
My lord, only one submission, my lord. This is order dated 11/9/2024. In terms of the Honorable High Court, Calcutta order dated such and such, the regular service of the Ashok Sen Group for the purpose of MSCP has been recounted from the date of his regularization to the post of PWI grade 3 on 1984. That is wrong. 1983, that should be. Because the initial appointment, that is my lord's order, and that is the rule.
May I file my affidavit because he was on training? So for the purpose of
Training should be counted for MSCP. ওই অর্ডারটা ওরা দেখাচ্ছে না
No. Item 20 and 21, my lord, I'll pray for a passover, my lord. I am led by Mr. Lokhi Gupta, my lord. But 20 and 21, my lord, I'll pray for a short passover, my lord. I am led by Mr. Lokhi Gupta, my lord. Matter has been called, my lord. So, my lord, he has been, just a short passover, my lord.
I just think, Miller, this is that coal matter where Miller initially and judgment was passed. Mr. Miller Shiv Shankar Bandyopadhyay was appearing for the other side. Miller, once an order was passed, then Miller he came and requested Miller he appeared. Matter was reheard a judgment. Yes. Yes. Miller, I would like to Miller show 2-3 things. Miller, this review application is perjurious. Miller, I am quite sure my learned senior friend, Miller, my revered senior friend has not been Miller told the facts of the case. Video Miller will do that and come back.
You have filed connected application.
Yes, yes, we have filed.
This Miller can one possibly.
21, my lord, item 21, 268. WP number, RBW number 2286 of 2020.
कैन नंबर का जज सर
Possibly can
नंबर
one.
नहीं करना
Can one. Can one.
Can number 1, sir. Can number
नंबर 1
Can number
कैन 1 नंबर को सब किच्छु नहीं आरबीडब्ल्यू नहीं
my lord.
yes memo and application
And my lords will kindly keep Miller the point of maintainability of this Miller review application open.
always तो content of maintainability रखो
If at government, I cannot resist my temptation, Miller, to show this Miller to your lordships. Kindly take me the certified copy of the Miller order, the last page.
Had any such temptation?
Miller, I think Miller, this should tempt your lordships also. Kindly Miller, just have a look at the seal of this honorable court. Miller, on the last page of the certified copy, kindly see the date of application and the date on which Miller the fees is being notified.
এইখানে পুরো ফাইল থেকে কন্টেন্ট ফাইল করেছিল এখানে ছিল তারপর আমাদেরকে মেনশন করতে হলো তারপরে ফাইল ছাড়া হলো তারপরে এটা হয়েছে যেহেতু ওরা কন্টেন্ট ফাইল করেছিল
unheard of.
নিচে ডিপার্টমেন্টে যাচ্ছিল না আমাকে মেনশন করতে হলো জজ সাহেবকে তারপর জজ সাহেব ছাড়তে তারপর এইসব হয়েছে আমরা কি করবো Your Lordship will remember, my lord, that I have to. But your Lordship will remember, my lord, I have to mention before your Lordship, my lord, to release the file, my lord. As they had filed a contempt, my lord, the file was over there, my lord, in your Lordship office, my lord, in court, my lord, and it did not went to the office, my lord.
No.
Thereafter, I mentioned before your Lordship direct.
Yes.
My lord, it was not coming. We could not understand, my lord, why. But we take steps, my lord. We asked them, my lord, why it is not coming.
The date of notifying the charge.
Yes, but after 5 months,
But
by the office, by the department.
If a cause.
Millard, I'm not blaming him, Millard. I'm
Yes,
showing
well, why-
the conduct. Millard, I'm showing, Millard, I'm not blaming my learned friend at all. Millard, I'm showing Millard the department's Millard action in this. But 5 months, Millard, the department takes. Millard, unusual. না না তোমাকে বলছি না it's unusual.
Was tagged with that.
And my lord knows, I'm sorry. Well, there is a direction.
Law of limitation has no application and it is entirely up to the discretion of the court, which is a court of record.
Justice Bhaskar Bhattacharya.
But I'm
That's
not
a
on
Bhaskar
limitation.
Bhattacharya, and before that, my lord, in the ILR Andaman and Nicobar, the Lieutenant Governor versus Gulshan Bibi.
No, he is not taking.
I'm not on limitation at all.
Not
Millard,
on
had there been a
limitation. He
delay
says
confirmation, yes.
that when it was
Something that draws away.
by notification is after 5 months. Maybe if on papers you are not responsible.
Yes.
On papers you are not responsible because the date was notified about 5 months there.
Yes. To that, my lord, we have.
He is not at fault. He is wanting to show that why such
The
long
sweet
time was.
coincidence was that Millard, after Millard, they could gather the new documents. Immediately after that, Millard, the notification came from the Department of High Court. Will indicate everything in our office. Great. Great.
Your Lordship, I am appearing for the petitioner on behalf of my learned senior. I am only praying for not today, Your Lordship, only not today.
I'm for the alleged contemners. I think you're.
I am only praying
Very
for
well,
not
sir.
today, Your Lordship. My learned senior is unwell and has not come to the court today, so I only not today.
Keep it
Next after vacation.
1 week after vacation.
Same, Your Lordship. Item
Same
number-
order may be passed, my lord. Same.
An adjournment has been prayed for on behalf of the petitioner, though Mr. Nondi, learned advocate, appearing for the alleged contemner or contemners.
Contemners. Made only one person as a contemner, but there are other
Contemner
respondents,
is present.
officials also. They didn't make it.
Thereof, list the matter for further consideration. Under the same heading in daily supplementary list of this court 1 week after the vacation.
আচ্ছা, please.
পরেরটাতেও same order করে।
22 and
Both
23.
the matters.
Both the
22.
matters. Similar order may be passed.
22.
22 and 23.
22 and 23.
Lordship.
24, I am for the respondents. It is that matter, my lord, where on behalf of Kendriya Vidyalaya, your lordship, by the last order, your lordship.
Yes.
Now here, my lord, I am ready with the matter, but one difficulty is there. That is, my lord, I intimated them also. But tomorrow, yesterday, I got an information from the CRPF. I also contacted them. CRPF told me that you kindly make a communication with the principal. Now, I didn't make communication with the principal. I made communication with the assistant commissioner. Probably he passed the original order. Now, one difficulty is that why I am asking your lordship just to adjourn it for 7 days, only for one reason, because I have thoroughly gone through the order. What I find is that, rightly or wrongly, department passed an order. It was a, two increments were cut off with cumulative effect. When he preferred the appeal, appellate authority, my lord, they didn't discuss anything. They simply stated that, yes, this is the order, disciplinary inquiry officer passed such and such a, you also made these and these statements, hence we allow, reject the appeal. So it is a fit case for remand. What I suggest is that, my lord, unless, my lord,
I'll be praying for setting aside of the inquiry report as well as the disciplinary thing, because
that is separate issue, that is to be.
I'll be praying for not for remand. When the materials are sufficient before the court.
Oh.
And
that may be
question
the
of
subject
remand-
matter of the matter.
remand does
I
not
just
arise.
want, my lord, after 7 days, your lordship,
Mr. Chatterjee,
just after 7 days, your lordship, take up this matter. On the next week, my lord, let it be disposed of. It is a, my lord,
because there is a gross violation of principle of natural justice.
I also find.
My defense witness has never been called upon. The documents which I have relied upon as a delinquent employee, out of 30 documents, 6 has only been given inspection. Documents has not been supplied. Only inspection.
Even the order
And
also, my
that
lord, is
too, and that too, inquiry officer has said that if those are not confidential documents, presenting officer should supply. Later on,
keep it not this week.
Yes, only not this week, my lord.
Here in the list, if it is reached, it is done. Otherwise,
Otherwise, they may held me responsible because, my lord.
yes, next 25.
But I appear for the respondent.
Is your other side?
But on the last occasion, one Subroto Samanta appeared.
Mr. Samanta
2009, my lord, I was entitled to the.
Mr. Samanta is sitting there.
No, he's Subroto Samanta.
Oh,
Subroto Samanta. Non-grant of upgradation under the DSCP scheme after 20 years of service. My juniors have been given, but I, in exclusion of my
readings exchanged.
Everything complete. 2009, my entitlement was there. On the last occasion, they told that medical officer, my lord, selection grade under 20 years of service under the DSCP scheme.
Your client has retired.
Retired. They're enjoying the interim order.
We can dismiss it, but that will not inure to your benefit.
Let us see, my lord. Or your lordship can, my lord, following the judgment of Devdotto, and thereafter, my lord, following the Guhata Grota's case, that uncommunicated adverse remark was considered.
Then come next week, let us.
Then your lordship kindly fix, my lord, any time.
It will be there in the.
Kindly fix, my lord, otherwise they will not, my lord.
Prior to vacation, Mr. Sen, we cannot fix the time. It will be there in the list.
I am under pressure by the client.
Yes, next.
Then, my lord,
practice. Is it pressure?
The only thing, my lord, I am under the pressure. That I retired since 2009. I am suffering interim order. Please do something. Do something.
What interim order you have? Oh, this.
He is suffering interim order. He is suffering the interim order. Since 2009, the petitioner is suffering interim order.
Last occasion, on last occasion they appear.
Yes.
Today
They told that. Why appear? They told that they have no copy of the reply.
I supplied them the copy of the affidavit reply.
All right, pass over, you bring him. Get hold of him and come before us. Yes, next. If we dismiss it for default, whether you will be any purpose, and again restoration, again treat, again hearing.
At best, today we can dismiss for default.
I have got his number, let me call him.
Yes.
Yes, follow.
But there are 5 matters, all from the tribunal, 26 to 30.
Identical matters. I have filed the application for speedy hearing of the matters because we are suffering an interim order with regard to the final publication of the final result of the
Filed an application.
Application in all the 5 matters, my lord. I filed applications. Can
Mr. You are for?
But I am for the petitioners.
And you are for Union of India?
Yes, my lord.
Any
2000
order is surviving?
Yes, my lord. But we are prevented.
Not to pass a final order. That was the only thing.
Disciplinary proceeding.
The disciplinary proceeding, it was dismissed at the first juncture by the learned tribunal. We came before this honorable court. The honorable court said, proceed with the departmental proceeding, but do not pass a final order. And also your order of suspension will be subject to scrutiny by the honorable court. This was the order passed. 2015
was that order passed?
2015
By a coordinate bench.
by a coordinate.
And opposition reply is complete.
I filed opposition, but no reply I have received.
Opposition দিয়েছো আমাকে কপি দাওনি মনে হচ্ছে
Opposition we find it.
We have not received a copy.
In any manner, I can supply another copy.
তাহলে শুনবো কি করে?
Can you fix another date, my lord, so that I can.
Because there was no reply there. Nothing was there. The first date was dismissed. After 2 days, it was dismissed without
Mr.
exchange.
Basu, give a copy immediately.
But today, I mean,
But in the 5 matters, because all are parallel.
All the matters you have filed opposition.
Yes.
একটাতেও দেয়নি আমাকে কপি না কপি নেই আমার কাছে দেখো in my file it is not there.
No, it is not with the record also. Yeah, affidavit in opposition record, but you have not. Obviously, he filed the
the problem, my lord. I faced. The last action I filed the opposition, my lord. I found prior to that.
Why have we not recorded that? Oh, Mr. Basu, yes.
Because I found earlier.
You have filed another application for vacating interim order.
Yes, sir. Because
that you have given copy.
That is
Not vacating, we have not the vacating. They are asking for appropriate order so that they can pass the final order. But the main matter is required to be considered by my lord. That will finish off the entire matter. তুমি তো আমাকে দেবে একটা, আমি তো তার জবাব দেবো একটা, আমাকে দিয়ে দাও, তারপর আমি জবাব দিয়ে তারপরে।
So you will give today.
By today, I'll give copy of it.
You file reply.
But only thing is because much water has flown there at that time, my lord, it was just the starting of the proceeding. The proceeding has been completed. We have to bring that on record. That means we have to annex all the documents subject to.
You participated?
Yes, we participated because the court passed the order.
What document you will bring?
My lord, because they continued me under suspension wrongly.
Annex that with your reply.
All those, yes, my lord, that has to be given. All those documents, and there will be voluminous documents. That's the problem.
Earlier occasion, you did not appear, Mr. Sound.
My lord, the other day, that, my lord, I actually, what happened is your lordship took it up at late stage. It was before the other court, I missed it.
Mr. Basu, learned advocate appearing for the respondents, have filed an
'28, '29, '30.
Mr. Vasu, we will not go into that vacating application. To appear, advance your argument on merit.
For early hearing of the matters.
That application is for early hearing.
No. Yes, my lord, we are suffering the interim order, my lord. Unless you file an application, it could not be.
All right, come.
That's
Give that copy to him also.
Yes, that's a application.
Yes, next.
I'm grateful.
Lordship, my senior is in another court. I'm praying for short passover.
I'm for the response.
31. 31.
I'm for the petitioner. My senior is in another court. I'm praying for short passover.
Okay. We'll go beyond the vacation. কি order করা ছিল?
1 week after vacation.
An adjournment has been prayed for on behalf of the petitioner. Petitioner 31. Though Mr. Bajpayee, learned advocate appearing for the respondents, is present. In view thereof, this the matter for further consideration under the same heading in the daily supplementary list of this.
I'm sorry, extremely sorry.
Petitioner.
Petitioner, my lord.
Affidavits complete.
My lord. Affidavit deviation. Second judge. My lord, second judge's copy is. Photocopy was given. Photo affidavit service. ঠিক আছে এটা out. Xerox দেওয়া ছিল।
Is a mandamus appeal or tribunal appeal?
Tribunal. My lord, case is, my lord, that there are several litigations actually was done by the petitioner. On several occasions, petitioner had to come before the Honorable Court as well as the tribunal. And finally, the Honorable Justice, presided over Honorable Justice Nishida Matre, Division Bench, passed an order. If your lordships kindly have a look to the order, page, my lord, 38. Page 38 of the petition.
This is an interim order passed.
No, final dispose, my lord, finally disposed of by the tribunal.
Where tribunal? Oh, that was the previous round of
Previous round of litigation.
So tell us the story, what happened?
Well, the story actually, petitioner was charge sheeted initially in the year of 1989. That charge sheet was withdrawn.
Now you are stealing, sir.
No, I'm retired.
You have retired.
Well, I have retired.
Achha. Then what happened? Charge sheet was issued against you.
Charge sheet was issued maybe against the petitioner in the year of 1989. And my lord, that charge sheet was withdrawn without speaking any reason. And my lord, long after thereafter, another charge sheet was filed for the same reason. And that was, my lord, I challenged with the tribunal, and that was quashed. Then they preferred the writ petition before the Honorable Court. Then Honorable Court remanded back the matter to the Honorable Tribunal. Tribunal finally, our application, dismissed our application, and my lord, dismissal order was upheld.
dismissal from service was upheld by the tribunal. Then I came before the Honorable Court. Then the Honorable Justice Matre, page 38 of the writ petition, that order was passed.
All right, what order was passed?
Order was passed, my lord, that charge sheet was quashed, and my lord, he was
Second charge sheet.
my lord, said charge sheet.
Second
charge sheet, yes, my lord, I'm sorry. Second charge sheet was quashed, and my lord, respondent was directed to reinstate me.
All right.
And I have been reinstated. And yes, my lord.
Then
I've been reinstated. Thereafter, my lord, ultimately I retired. But in the meantime,
when did you retire?
I retired, my lord, on
All right, you have got the pensionary benefits.
No, I didn't get the entire pension benefit. My lord, partly I received. Thereafter, my lord,
So you were reinstated.
Reinstated.
After that, why did you go to the tribunal again?
Yes, my lord, after reinstate, my lord, that matter was remanded back to the tribunal for ascertaining the fact whether the writ petitioner was engaged in any service during the period of disciplinary proceeding. My lord, then the Honorable Tribunal passed an order directing the respondent authority to give a reasoned hearing to the writ petitioner and to pass an order. Then, my lord, the authority passed an order rejecting our claim. Then again
Your claim for back wages.
Back wages, my lord. For the period when I was that proceeding was
So
initiated.
why did they refuse? You were engaged in another.
No, I was not engaged. Their point is, my lord, that is no work, no pay. Since I have not done any work, that is why I should not be allowed to enjoy the.
You suffered suspension.
Yes, I suffered suspension there. Yes, my lord. I suffered suspension as well as finally dismissed me from my service for a long period since 1990, my lord.
Show us that order which you challenged before the tribunal.
Yes.
The order of the coordinate bench has no further effect in this matter because it was sent back.
No, my lord, Lordship's kindly, that is very essential because that
So show us
observation.
only that portion of the order.
That portion I am showing, my lord. My lord, page 49. The operative portion is, my lord. My lord, I'm just reading the second paragraph. We therefore have no manner to doubt that the procedure adopted by the respondents to appoint a new inquiry officer in order to ensure that the petitioner was found guilty is untenable. There is no reason recorded by the disciplinary authority as required under Rule 10 for re-inquiry. Assuming we consider this procedure adopted as one where the disciplinary authority has remitted the inquiry to the inquiry officer for a fresh hearing, it was necessary for the disciplinary authority to remit it to the same inquiry officer and not to appoint a new inquiry officer. In this circumstance, we have no hesitation in holding that the respondents have violated the provisions of Railway Servants Discipline and Appeal Rules 1968 by ordering a re-inquiry. We need not consider the proprietary order for a fresh inquiry as we have already held that the re-inquiry in the circumstances of the present case was impermissible. The writ petition is thus allowed. The respondents are directed to reinstate the petitioner in service with continuity of service forthwith. However, the aspect of the back wages to be paid to the petitioner will have to be considered by the tribunal as there is no material before us to indicate whether the petitioner was unemployed after he was dismissed from service on 2nd August 1994. The original application is remanded to the tribunal only for the limited purpose of ascertaining on affidavits which may be filed by both the petitioner and the respondents as to whether the petitioner is entitled to back wages and other consequential benefits from 2nd August 1994 till the petitioner is reinstated in service.
When were you reinstated?
My lord, I was reinstated in service, my lord, in 1994. Date, I'm just giving second, my lord, page 52, the order of reinstatement. Page 52. My lord, that is, my lord, 15th April 2013. I was reinstated.
So back wages for the period from
1994 to
2nd August
2013.
1994 to 15th April.
My lord, 15th April 2013, my lord, I was reinstated.
All right, come to the tribunal's order.
Yes, my lord.
Anything, any other document you
Yes,
want?
my lord. Before that, my lord, if you will kindly have a look to the reason order passed by the authority. That is, my lord, dated 15 June 2018, annexed at P6, page 55. It's a long order. I'm just reading, my lord, page, if you will kindly have a look to the page 58.
No.
Should I read it?
Page 58.
Page 58, my lord, speaking order. It starts from page 53.
Yes.
55, but
yes.
My lord, speaking order from the directives of the Honorable Court, Honorable Tribunal, Kolkata, the respondent is to consider 4 aspects as per follows: whether the applicant was willing to work, whether CLW, I mean Chittaranjan Locomotive Works Administration prevented him from working, whether the applicant served any organization after his dismissal from service till the date of his reinstatement, give a speaking order in accordance with the decisions rendered in a dispute case of the Commissioner Karnataka versus C. Muddaya. That is Mala, no work, no pay. That is there. And this is a tribunal's observation. Pursuant to that observation, Mala, speaking order was passed as they have said. Mala, accordingly, the above aspect.
Where was the tribunal's observation?
Not, yes, Mala, I am giving.
After you were reinstated.
After reinstated, Mala, the matter was remanded back to the tribunal, and Mala, tribunal passed an order to pass a reason order.
After reinstatement, they did not take any decision. That is why you again visited tribunal.
No, Mala.
Tribunal said pass a speaking order.
No, Mala. There was a special direction passed by the Honorable Court to ascertain whether the petitioner was working during the period of suspension.
That order was passed
by the Honorable Justice Matre. Yes, Mala.
That is what he has said, that to indicate whether the petitioner was employed after he was.
Yes, Mala. Yes, Mala. That is.
On the basis of this, the reason?
No, Mala. No, it was remanded back to the tribunal, but tribunal, without considering that aspect, straightway sent to the authority.
Where is that order?
Yes, yes.
Order pursuant to which the speaking order was passed.
I'm giving this, Mala. That is, Mala.
Just only consider.
Only consider.
Then this order was, yes, you are placing.
Against that, my lord, we challenge before the tribunal against this reason order.
Yes.
So and thereafter, my tribunal passed an order.
Very good. So you are wanting to show us which the speaking order?
Yes, my lord.
So show us what you are showing. Yes. Page 58.
Yes, ma'am. Well, accordingly, the above aspects are examined below. Whether the applicant was willing to work. The applicant was called for personal hearing in which he was confirmed that he was not employed in any other organization during the period he was dismissed from railway service, that is 2nd August 1994, 58, page 58, to the date of his reinstatement, that is 18th March 2013. As far as his willingness to work is concerned, no clear conclusion can be drawn, as he has replied in regard to his livelihood during the period he was removed that his wife is a railway employee and he stayed with her. This is the explanation of the petitioner. Next, whether the Chittaranjan Locomotive Works Administration prevented him from working. On perusal of this is the observation by the authority, not by the tribunal also. On perusal of the case, it is seen that the removal of Sri Ashish Kumar Ghosh from service on account of the fraudulent appointment was upheld by the competent court, CAT, Kolkata, and the above status continued till the orders of reinstatement passed by the Honorable High Court, Kolkata on 18/12/2022. 12. Therefore, the administration has not prevented the applicant from working in railways as his removal from service was in accordance with the law as upheld by the Honorable CAT, Kolkata, and subsequently the matter was sub judice till the order were issued for his reinstatement by the Honorable Court, Kolkata. Further, in his personal hearing, nowhere Sri Ashish Kumar Ghosh has indicated that he was willing to get himself engaged in any other organization. He has indicated that he managed his livelihood as his wife is employed in Chittaranjan Locomotive Works. There is no record to establish that Chittaranjan Locomotive Work Administration prevented him from working in any other organization for the period he was removed from the railway service. Whether the applicant served any organization after his dismissal from service till the date of his reinstatement. In personal hearing, Sri Ashish Kumar Ghosh has confirmed that he was not employed in any other organization during the period he was dismissed from railway service, that is 2nd August 1994 to the date of his reinstatement, that is 18th March 2013. Next, the application of decisions rendered in Commission Karnataka versus C. Muddaya 2007, that is that they have stated the decisions rendered in the legal cases between the commissioner such and such indicates that although a view can be taken that no payment of arrears allowances should be made to the employee for the period of employee had actually not performed the work on their post, and the Honorable Court has held that they are conscious and mindful that even in absence of statutory provisions, normal rule is no work, no pay. However, in appropriate cases, a court of law must take into account all the facts in their entirety and pass an appropriate order in consequences with law. The court in a given case may hold that the person was willing to work but was illegally and unlawfully not allowed to do so. The court may, in the circumstances, direct the authorities to grant him full benefit considering as if he had worked. It therefore cannot be contended that as an absolute proposition of law that no direction of payment of consequential benefit can be granted by the court of law, and if such directions are issued by the apex court of the country as has been done in the present case. In the above case, the commission such and such, the Honorable Court have given orders to the authorities, the respondent, to pay the back wages to the applicant. But the authorities denied the payment of the back wages, taking the shelter of legislative ruling. Therefore, the administration has not implemented the orders of the Honorable High Court of Law. Whereas in the instant case, it is seen that the Honorable High Court, Karnataka, Kolkata, has directed the railway that the applicant petitioners may be reinstated in his service. Well, the total distortion of fact order in service with continuity in service forthwith. But no specific order was issued to the respondents for paying the back wages. The subject matter of the payment back wages was referred to CAT Kolkata by the Honorable High Court. The CAT Kolkata has directed the respondents that a personal hearing of the applicant should be done and speaking order should be given. Therefore, in the instant case, no court has ever passed any positive direction to the respondents for payment of the back wages. Therefore, the subject case differs from the case of the Commissioner of Karnataka versus C. Muddaya. On this account, in the subject case, there appears no specific ground to consider the payment of back wages to the applicant in the light of the fact that no such directive has so far been given by any court of law, and since the applicant was not prevented from working during his period as established in para 3 above, in the light of the above, payment of back wages cannot be agreed to on the following grounds reiterated again. No conclusion can be drawn whether the applicant was willing to work as brought out in para 2 above. The applicant was not prevented from working by the Chittaranjan Locomotive Works Administration as concluded in para 3 above. In the case of Karnataka, Honorable High Court has given the orders to the authorities to pay the back wages to the applicant, but in the instant case, no such order has been passed by the court of law. So
but on 2nd April 2013, you were 2nd August 1994, you were
dismissed from service.
Dismissed.
My lord.
So from 94, that dismissal was ultimately set aside by the High Court.
High Court in the year of 2012.
So how could you have joined? There was an operating dismissal order against you.
My lord, there was a direction to reinstate.
Reinstatement was done thereafter.
Yes, my lord, thereafter.
From 1994 till the order was passed by the High Court.
My lord, I was
How
unemployed.
can they say that you did not, no work, no pay principle is if your denial to join the work?
Yes, my lord, that is there. That is my submission. That
How
I was
can
not
they
allowed
allow
to.
you join?
I
You
was
were
not
a dismissed employee.
My lord, I was not allowed to join my duties.
How can you join? You are a dismissed employee.
Yes, that is on. If the my lord, that disciplinary proceeding is bad in law, in the eye of law, my lord. In that case, my lord, if I was not allowed to continue my service.
No, it was bad in law decided in the year
2012.
2012.
My lord.
So from 94 to 2012, how could the authorities have allowed you to join?
No, that question does not arise whether I was in employment or not during the period of disciplinary proceeding.
No work, no pay principle in the industrial matters. That suppose if you were not allowed to join by the employer, you can establish that.
Yes, my lord.
Then no work, no pay principle will not apply because you were willing to work.
Yes.
But the employer did not allow you to.
Yes, ma'am. That is my. I'm grateful. That is also my submission. Yes,
The
that is
argument will be that no work, no play principle
will not applicable.
Straitjacket formula cannot be applied.
My lord, my lord.
Since I was dismissed in 94 and I approached the court, ultimately court decided in 2000.
My lord, I'm grateful. This is my submission.
Yes, now show us your
tribunal's order. I can place before you.
Now come to the tribunal's order.
My lord.
What is tribunal said?
My lord, tribunal's order at page 97. My lord, it starts from 97. If you lost this kindly.
You were working in which post?
All right, initially I was a store assistant.
What was the charge against you?
Actually,
Defalcation.
no, my lord, I produced a fake certificate regarding
certificate?
my. That was I declared myself as an ex-serviceman.
Oh.
That is the allegation.
And the disciplinary proceeding was set aside.
My lord.
Since the disciplinary authority sent it back to a person who was not the initial inquiry officer.
That is a subsequent inquiry proceeding. But initially what has happened? Charge sheet was framed and for long 2 years, they did not take any step. In the year of 89, it was first issued in the year of 89, first charge sheet. And thereafter, my lord, in the year of 1990, end of 1990, my lord, that charge sheet was withdrawn.
Prepare a short list of dates giving those facts.
Yes, my lord.
Yes, now come to the order of the tribunal.
Order of the tribunal, page 97, my lord. It starts from page 97.
What did they show us the relevant portion?
Yes, I'm showing the relevant portion, my lord. My lord, may we permit to read the page 100?
We have not stopped you.
Page 100.
Jointu bhaite je ছিলটা আপন তো
My lord, paragraph 6, I'm reading.
Yeah, just once.
I'm sorry. No.
Yes.
Malaj, page 100, Malaj.
Have you brought Jayanti Bhai
Malaj,
judgment?
yes, I have brought. I'm grateful to you that and justice Indira Banerjee and Malaj.
We give it to you.
I have brought. Malaj.
It was not justice. It was by our Chief Justice.
Actually, at that point, Honorable Justice Chandra was not the Chief Justice. He was the senior judge, and Honorable Justice Indira Banerjee was.
Oh, leading judgment is author was Indira Banerjee?
No, author was Justice Chandrachud. Honorable Justice Chandrachud.
Show us page.
Page 100.
Page 100.
I'm just
internal page.
Internal page 5. I'm sorry. probably it doesn't paginate it properly. হ্যাঁ, হ্যাঁ, দেখাচ্ছি, বলছি। Malad, I'm just. We note that the applicant was dismissed from service in the year of 1994, which he challenged by way of OA in 1995. Strangely enough, did not press for hearing of the OA until October 2002, when the OA was dismissed. That order was assailed in WPCT number such and such, which was disposed of in 2012, remanding the matter back to the tribunal on limited issue of back wages and consequential benefits from 2nd August 1994. In the present backdrop of the case, and in view of the decision of the Honorable Apex Court rendered in the case of Union and Territory, Chandigarh versus Brijmohan Kaur, 2007-11 SCC 488, wherein the Apex Court held that the direction of the tribunal, which is affirmed by the Honorable High Court, in our view, is against the old canons of law directed by this court. It is settled law that when an incumbent does not discharge any duty, the principle of no work, no pay would be applicable. This consistent view has been taken by this court, keeping in view the public interest that any government servant who does not discharge his duty should not be allowed to draw pay and allowances at the cost of the public exchequer. We feel that the principle of no work, no pay would apply in the present case. Further, without specific order of reinstatement, but it is totally, there is a specific order. There was no occasion for the respondents to take the applicant back to service. Therefore, the prayer in regard to back wages is disallowed.
That is because there was no specific order of reinstatement in the midst of the final disposal.
In the midst, but in the concluding part of the judgment, there are lots of
concluding court has said. I think the tribunal made to say that you did not obtain any interim direction that allow me to join. Anyway, then.
And then, thereafter, that is merely observation, and with regard to certain promotions. Certain promotion has also been given to me till the retirement, but certain promotion has not.
Promotion you will not get. Promotion is a participation in a process. You have to make yourself eligible. Supreme Court has now said consequential benefit do not include promotion. You can say about back wages.
Yes, now I'm only.
If you are wanting to argue that I must be given promotion also, then you have to cite your authority to that.
Yes, I shall.
Yes. So you are not serious about your promotion. You want the money.
Yes, back. Yes. I have prayed there for promotion also, and that is why.
What you will get? That will anyway. Argue. Next.
Next one of the.
Yes. Then what happened in? Oh, you got promoted. Read the next paragraph.
In regard to the prayer of the applicant for consequential benefit, the following his reinstatement in view of the specific explicit stipulation in the panel dated 14/7/2015 that it was provisional subject to interpolation of the applicant's name and which could not be included in the select list due to non-receipt of the decision of the Honorable High Court Can 486 on such, which is stipulation made it imperative for the respondents to interpolate the applicant suitably as per seniority in the panel once the application was decided. We direct the authorities to interpolate the name of the applicant and to accord appropriate financial benefits by fixing his pay with effect from the date of his juniors were allowed such promotions, grant him arrears of salary and revise his pension accordingly. The benefit be extended to the applicant within a period of 3 months from that. Actually, I joined, after my joining, certain promotions were given. That is there.
So you were given a consequential benefit?
Yes, Malan.
You did not challenge that? So, no, consequential benefit, this order was passed after your retirement, tribunal order?
No.
When did you retire?
On 18/11/2018.
That is after retirement order was passed. 18th November.
No, Malad, thereafter, Malad, another litigation, Malad, actually,
No, Mr.
thereafter, Malad,
Gupta, consequential benefits, it appears that paragraph 7 is in your favor. Did you get the benefits of the direction?
Yes, Malad, I got the benefit. Yes.
Promotions and everything.
Yes, Malad, yes.
Very good. So, only you argue only
back
at the
wages.
point of
Only back wages.
So, Jayanti bhai, dekho.
Yeah,
Or any other judgment you
yes,
want.
this is Jayanti bhai, Malad.
That will be 30th/11/2018.
30th November 2008. Which paragraph you want to show?
Yes, Malad. Next time আমি দিয়ে দিচ্ছি ইয়ার সাহেবকে বলে দিই Malad, I'm just this judgment obviously, Malad, that is latest judgment.
No. We said that is why you have to place no. What other judgments?
I'm sorry. Before that, I may be permitted to cite.
He told you to go through.
No, Malad. This is actually, in our case, it is squarely applicable.
Deepali's case supports.
Yes, Malad. It is squarely applicable in our case, Malad.
No. How applicable? Everything was said 5 lakhs compensation.
Yes, only compensation. That is.
Compensation, not back wages.
Yes. Malad, before that, Supreme Court case, I think.
Yes, before that, what you have to say? No. When you have placed it, tell us the paragraphs. Which paragraphs you are relying?
Yes, Malad. That is, Malad, page 10, 11.
Paragraphs 10, 11.
10, 11, and then, Malad, paragraph 14.
Yes.
And thereafter, Malad, 15, 16, last 17, conclusion.
Yes.
Malad, before that, I'm also citing another judgment, that is Malad AR 2016 Supreme Court, page 157. Yes, Chin.
2016.
16. My lord, এই বইটা বার করুন, পেজটা বার করুন, 157. This is the
2016 which volume?
my lord, first volume.
AIR?
AIR Supreme Court, first volume, page 157.
Paragraphs?
Paragraph my lord, 3-4. It is 2 pages, 3 pages judgment, 2 pages judgment. Very small. Well, here I'm just reading the back note, head note. I'm just there handing it there. Constitutional Article 16, back wages, denial of. Appellant was reiterated from retired from the service 3 years prior to attaining his date of retirement. Subsequently, order of reinstatement cost. Fault lies with the employer in not having utilized service of the appellant for the said period of 3 years. Order denying him wages for period in question on plea of principle of no work, no pay. Actually, here in the insert case also, I was not allowed to join my duties. I was prevented to do my work.
How you were prevented means you are under an order of dismissal.
Dismissal, that dismissal order, that proceeding is bad. Wrongful dismissal, madam. Thank you. Case bar করে দিয়েছেন 157. এটা দিন।
184. Oh, this is another judgment.
This is the 2016 judgment. 157 page.
Oh, achha.
157 only.
Oh, achha.
Very small judgment.
Yes. Anything else?
Yes, my lord. Another judgment is, my lord, 2013 10 SCC. Page 324. Paragraph 22.
ওই বিশ্বাস অ্যাপিয়ার করেছে তখন
ওইটা নিয়ে আসা পরিশ্রম হয়েছে না
পাঠিয়েছো
Yes. Malad, this is also with regard to the back wages, Malad.
Para 22.
I'm just
read that paragraph.
What is the proposition?
Proposition, Malad. Here also he was dismissed from service, reinstated, and Malad back was not given back wages. There was a direction to give the back wages during the period when he was dismissed and proceeding was pending. During that period, Malad, he was
all right. Anything else?
Same principle. No, Malad, another judgment. It has just.
Okay.
কোনটা না আরেকটা যেটা বলেছিলেন
Deepali service. This was discussed in Rajni Bhai.
Yes, my lord. Jayanti Bhai. And my lord, another judgment passed by this.
Eighter কোন paragraph?
22.
This which paragraph you are arguing?
22, my lord.
I think that has been quoted in that judgment. Paragraph 22.
22.
This is reported in 2013 volume 10 SCC.
My lord. Page 324. in SEC. And this is my lord another, sorry.
Paragraph 22.
যেটা দিলেন প্যারাগ্রাফ ওই এটা দিন এটা না
Yes.
And my lord, another judgment passed by this honorable court, my lord, the coordinate bench has passed recently the order regarding my lord back wages. That is, that order was passed on August, 8th August 2024, passed by the Honorable Justice Borshak and my lord, the Justice Sabri. Here also, my lord, the same principle has been applied, and my lord, 2013 has been considered. Deepali Gundu's case has been considered, my lord.
Paragraph?
Paragraph, my lord.
All right. You will give us the paragraph when he starts arguing. You have finished. Anything else?
না একটু এই জাজমেন্টটা দিয়েছি না হ্যাঁ আজ কপি আছে তো
এটার আমাদের কাছে কপি
and other two judgment that is old, that is 1994 supplementary 3 Supreme Court cases, page 671. এর কপি দিন আর একটা কপি
Supplement 3.
Malad. I'm giving
Pages?
Page Malad 671.
Paragraph?
Paragraph Malad.
All right, you find it out and tell us. Yes, Mr. Vajpayee. What is the next citation?
Character citation follow.
হ্যাঁ আরেকটা 94 হ্যাঁ আরেকটা যেটা দিলাম হ্যাঁ এইটা এইটা হ্যাঁ another 1994 supplementary volume 2 SCC
1994
supplementary volume 2
supplementary 2
and Malad SCC page 395.
Paragraph? So these are
2 pages judgment, Malad. বই থেকে প্রিন্ট করে ছাপিনি বলে দিয়েছেন সাইটেশনটা দিয়েছি
yes, Mr. Vajpayee. Now, please tell us this thing. Suppose
I'm sorry, Malad. I'm sorry. Another judgment passed by your lordships, Malad. Malad. That is Malad.
Then we are out of court. If
And
your lordship has passed the order.
No, facts may be different. Why do you worry, Mr. Vajpayee? You also win cases from us.
The last spade
Mr.
used by
Dotto
him.
actually appeared for the Union of India in Red Cross Society.
Uh-huh.
Mr. Dotto appeared for the Red Cross Society. Yes. In
He
that matter.
appeared.
That matter, my lord, just now I got the information. Your lordship passed it.
Oh, that Red Cross.
Yes.
The matter material.
Yes. Do you have Red Cross?
No, I don't have
Oh,
just. I have
he
gone
put it
through
to your
He-
ears.
Yes, sir, he has helped me.
Is acting as amicus curiae.
We will inform this to Red Cross.
Yes. We need Red Cross help.
Yes, Research.
My lord, the question is, my lord, he has used many number of judgments. It would have been better had it been, although it is reported judgments, I feel, it would have been better to give me a copy of the same, but however, he has not spared any judgment.
You can take our copies.
My lord, the question is, my lord, the question is, this man, this petitioner, in place of his brother's certificate, using his brother's certificate of Air Force, I have taken it in the opposition itself.
Sure.
Opposition. Lordship, kindly see. This is the antecedent. No, sir, opposition.
Paragraph.
No, paragraph 4, Roman 3. That since the appointment of the petitioner was on ex-serviceman quota, the petitioner was a store khalashi. He appointed on ex-serviceman quota. The petitioner submitted Indian Air Force discharge certificate number such and such, issued under seal and signature of wing commander. That the proceeding from the screening test of ex-servicemen for appointment to the post of khalashi and other categories were held as per Annexure A, page 1. Petitioner Sri Ashish Kumar Ghosh appeared under serial number 9 on the basis of ex-serviceman quota. That Indian Air Force discharge certificate produced by the petitioner for claiming appointment was sent for verification to the Air Force record, New Delhi, by the Vigilance Officer Chittaranjan Locomotive Work, by letter number such and such, addressed to the Vigilance Officer. Air Force record, New Delhi, by letter number such and such, dated such and such, addressed to the Vigilance Officer Chittaranjan Locomotive Work, indicated herein that the service number such and such reflected in the letter number dated of Chittaranjan belong to Sri Binoy Kumar Ghosh. Binoy Kumar Ghosh is the brother of this Ashish Kumar Ghosh. He, by utilizing this thing, served the company for a considerable long period of time. But the appointment condition was that this is provisional, subject to verification of documents. During the verification period, this was revealed that he is a fake person employed in the CLW for a considerable long period of time and subsequently, by way of this Honorable Court's order, got reinstatement, got promotion, got all retirement benefits. His wife is gainfully employed in CLW. And now, after getting everything and retired in 2018, then now.
When you said that this was this surfaced at the time of verification.
Verification.
Then why did you appoint him?
No, my lord, that's why, my lord, an inquiry was initiated.
Prior to appointment?
No, after this letter was received, my lord, subsequently, he was.
16th of October 2018. Is that letter here?
Which one, my lord?
That 16th of October 89, which you are saying, that serial number such and such of 16th October belong to Binoy Kumar Ghosh, who is the brother of the petitioner.
My lord, that is really not with me, but I have used this on affidavit because that
because this is a change brief, so I have been entrusted
No,
with this
that
brief.
has not been annexed to the
No,
opposition. Very good.
because
Then what more?
Yes.
What else you want to point
my lord,
out?
my lord, my question is, my lord, that this back wages is not automatic. That once I am reinstated, I will get the back wages. It depends on there are
Consequential
But yes.
benefit is also not
Yes,
automatic. So why
it is
did
not
you-
automatic, but the question is, my lord, the order speaks. Lordship, kindly see the order. My lord, the Honorable High Court's order on the question of consequential benefits and other issues, my lord, that has been done in terms of, in the speaking order also it has been said that
Why did you give the consequential benefit?
because of the order passed by.
Allegation is one. Allegation is fraud. You have shown your brother's certificate to get appointed. So how could you give consequential benefits to that person?
Because of the order.
The court did not give any such direction.
Yes, yes.
No, court said that his back wages will be considered only.
Continuity of service.
Yes, but why you gave him promotion? He never asked for promotion.
My lord, in
Tribunal itself said give promotion.
Yes.
So you did not challenge that.
My lord, that part we have on the basis of the tribunal's order. I am saying that the promotion was given.
Right. So
rightly or wrongly, whatever lordship considers.
Promotion is far-fetched. Back
Yes.
wages is easier.
Yes, yes.
That if I
Yes.
can prove that I was not allowed, I will get the claim.
Yes,
But
yes.
consequential benefits is a separate thing.
Because that was not in the list, but subsequently they wanted to interpolate the name of the petitioner for the purpose of promotion. So question is, my lord, that it was done. Promotion was given and he retired with full benefits after in 2018. And now they have come with this application for back wages. So, my lord, I am the contention as
His wife is a railway servant.
Yes.
She is still working.
no, yes, still working. And the question is, my lord, that
Same CLW.
same CLW. That is the problem. And the question is, my lord, after getting everything now, the only part left is back wages that he also wants after so many years of service by using somebody else's documentation and
No, Mr. Vajpayee,
a
please
fake service
answer us.
has been done.
Please give an answer to our question.
My lord,
This dismissal was in the year 94.
94.
From 94, its dismissal continued till the date it was set aside by the High Court.
Up to 2012.
2000. So during this period,
My lord.
how can you justify that the no work, no pay principle will apply? His contention is that I wanted to join,
Yes.
but I
No, that part they cannot. They cannot throw any of the one application or anything to that effect.
But if you have dismissed me, how can I go to you and say, allow me to join?
No, that is there. But the question is, my lord, they cannot show anything that they were not allowed to join. But that part definitely dismissed employee, how they will be allowed to join. But that is all. Whether he was working outside or not, my lord, that is very difficult to justify or ascertain.
Have you stated anywhere in your opposition that he was gainfully employed otherwise?
No, because that I don't know how on affidavit I cannot say that, my lord. The question is, my lord, if he is working
Did
elsewhere.
he make any statement in his
And
petition?
because the question is, my lord, if
Where is the original application? Original application by which this order was passed?
That
On
application,
which this order was passed?
first one,
Last one, back
last one,
wages.
last one, my lord, it is
You have
done.
annexed.
Yes,
Acha, show us any statement that you were not gainfully employed.
yes.
Stated anywhere.
But if the family is earning during this period, if the wages that is within the meaning of Payment of Wages Act, my lord, so
Mr. Gupta, Mr. Vajpayee, anything? Mr. Gupta and Mr. Vajpayee, learned advocates appearing for the respective parties, have concluded
क्या हरी जो है क्या हरी हाँ।
Who is your friend? Mr. Sen, who is opposing you?
I can't find them. But on the last occasion, my lord, they just took time saying that there was an earlier order. They will be able to have a right to inspect the records. Order of December 23. After that, we have also got a copy of the records. The some
Abid Devnath, ECL.
Yes. But when the land loser, under the land loser scheme, my lord, I had given my land to ECL. Certain amount of coal was given to me. Balance amount of coal was not given. That was my husband's predeceased husband's writ petition at that point of time. Then the husband, there was a policy that if the persons who had filed writ petition withdraw the writ petition, the balance amount of coal will be given. On that assurance, that writ petition was withdrawn. Despite an order was also recorded. So despite that, the balance amount of coal was not allotted. Then my husband, who is now deceased, filed the writ petition. In the meantime, the husband died. Wife pursued the writ petition was dismissed for default. Wife filed a fresh writ petition. They took the point of maintainability. Ultimately, my writ petition, I was allowed to not press and proceed with my husband's writ petition by substituting myself. So on that writ petition, my lord, an order was passed by this honorable court, prima facie recording that my land has been taken away. These are the records. They have not disputed the records. And further hearing was to be granted to my client. Based on that, a hearing was given. In this writ petition, we have challenged that order. Now the learned court, my lord, has gone in a totally different finding what was arrived at by the earlier writ court. Now he has gone into the question of the title of the original land, whether I have title in land to that land or not, which was not in issue at all in the earlier matter. Earlier matter, they, on the basis of documents, I will show your lordship 2 paragraphs of the earlier writ court's order, which records that they did not dispute the fact of land being taken over. But I would only pray before your lordship, my lord, if I will give them one notice, if your lordship kindly fixes the matter, because the person is suffering.
It will remain in that position.
Very well.
Give a notice and come back on Monday.
Yes.
If we reach, we will do it.
But if it can be taken in the daily list, if it is possible,
Mr. Sen, it will be in the daily list itself.
Very well, very well. I shall.
Or do we make it after vacation?
No, no. Let me take a chance. Let me take a chance. Since we have reached up to this level, where 2 days it has reached, let us take a chance, my lord. If I get the other side, my lord,
yes,
it will not take time, my lord. Your lordship will be able to. I shall give a notice to the other side, my lord.
It will remain in the list, retaining its.
Will your lordship record, my lord?
Mr. Sen,
Thursdays, can it be on Thursday? Friday, actually, afternoon, I will be in some difficulty. But if it
Keep it on Friday, Thursday then.
oblige, oblige.
Maybe by first of all matter will be taken up.
I'm extremely sorry.
Ready?
In this matter, I am led by Mr. Larned ASG. I can.
Matter is some
Yes, I-
2013 matter. You start the matter.
Yes, I start.
Now, if again Mr. Chakraborty is there.
Yes, ma'am. Yes. We are the appellant. अरे तो सारे 24 किलोमीटर
Just say come next week.
It may be fixed on any date, my lord. Supplementary list, any date, my lord.
Yes, supplementary list, it
Any
will
date,
appear same position.
At the top, it is no doubt, my lord.
Mr. Sen, you have seen we reshuffle the list. We
May I
take
pray
up
for one
return-
indulgence, my lord? The time may kindly be fixed. Any time.
Because the vacation is nearing, Mr. Sen, we won't be. It can be in the list. If it is taken up on Monday, you argue. Tell Mr. Chakraborty, if it is taken up next week, please don't take
Yes,
action.
yes. I will inform you.
Then you get it
Yes,
prepared.
I cannot.
A very simple matter, my lord. Really very simple matter. I was declared on the basis of uncommunicated adverse consideration.
Actually, my
Uncommunicated adverse.
because
All right,
railway
yes,
authority
next.
is not permitted to.
Oh, shit, what?
So after 4 o'clock, we will rise.
He's
We
reminding
override it.
today is Sunday, Friday evening.
So what?
So what?
কি হাঁপিয়ে গেছে না বললে কি এই তপন দা বলছি মামলা করে করে হাঁপিয়ে গেছে আজকে নাকি
He's here, he bulldozes into the court. Take up my matter.
এটা বলো দলিল পাঠাতে
Full of energy, Mr. Mukherjee. Full of energy. Lat sat cat.
My lord, before my lord rises, my lord, may I make one prayer, my lord?
Our
No, only thing, my lord, in respect of item number, my lord, 41 and 42. My lord, Monday, Tuesday and Wednesday, I might be in my lord circuit bench, Jalpaiguri.
Ask your junior to mention.
As my lord.
Sure.
Item 40.